the SOPEC, and you understand what goes on those two things. Now, if you have done that, then you are safe, you're fine to go. So we'll start the class. So our tutor is with us today. So we'll run the class alongside her. And in case of any question, you know what to do. Please make sure your microphone is off. Mute your microphone, mute your videos, and let's have a quick class, and everything shall be fine. Otherwise, Answer, can you hear me?
I can hear you, Senior. Good evening.
Yes, good evening. So I want us to start and start quickly.
Sure.
I've made you a presenter and recording the class, so we can start. Take it away.
Thank you so much. Hi, everyone. I hope all is well. I understand that you did your civil litigation paper today. I hope it was fair. I hope the day was kind to you. And just before I officially start, I would like to, for those who've never been in my session, I would like to introduce myself. My name is Immaculate. I go by Miss Maga. Some people call me Awino Maga. And I was once in your shoe. So I really understand what you're going through. So what we are going to do, we are going to make this very easy on you by going through everything. But at the same time, I want you to walk with me and just keep an open mind because time is of essence here. So we must really ensure that whatever we do today is, worth your time and that you're able to take in as much content as possible. I want to start the meeting or the session by wishing you all the best in the rest of the papers and just sending good vibes for the paper that you already did. I don't know if you guys can see my presentation. I don't know if you can see it. Let me just, I don't think you can see my presentation. So let me just go back and try to present again so that it comes on the screen nicely. And then we can just go right into it. I want an entire window. And for some reasons, I don't think that is what I'm going to get. Anyway, can you see any title? Law as a profession and not a business. If you cannot see that, then someone can unmute and just tell me very quickly so that we can figure it out. I hope
we can see that.
you can see that. Then thank you so much for just pointing that out. So let's look at this and I'll go by the course outline. So if you find that one particular slide has more than 3 topics, that's because it's meant to be so for this particular night. And the slides are, if they're not uh, on your way to you, they're already in your hands because I've already dispatched them. So they should be there at any point this night, but I also want you to follow closely here. So let's look at law as a profession and not a trade. And we usually say that in the legal field, we must pretend that the outcome of the client is more important than the profits that we are looking for. Of course, you pay to study from undergraduate, even from high school. You study so that you can pass your KCSE, and then you come and do your undergraduate, and then you come to KSL, which involves a lot of money, so that you can make a living, a decent living. But we have to pretend that what really matters is the outcome of our client. We want our client to triumph. And the idea is that law used to be an altruistic profession. Okay? Back in England, law it used to be free. Like orators, people who would be able to talk, people who are seen by the society as good speakers, good orators, would be called to present cases for parties who are in dispute. So that tradition has been carried to the present day. And the idea is, as long as my client is okay, because I owe my client duty of care, I owe my client the duty to act in good faith, then I'm not concerned about the profits. But that is not really the truth. The truth is that we must put food on the table. We are living in a capitalist society where you have to make a decent living for yourself. So that is usually different. And for the lawyers, we are advised to look at law as a profession. Then in that way, you're going to do all the things that are required of you by the professional ethics manual or unit or sphere, if that's what you want to call it. And don't look at it as a trade, because if you look at it as a trade, then that's where the problem begins. That is where we have advocate liabilities. That is where we have conflict of interest. That is where we have you facing the disciplinary tribunal. Okay, so us pretending that this is a profession then leads us to look at the meaning of a profession. And this is usually a vocation. It is like a calling, something you've been called to do. And we also have this with doctors. We have this with people in the ministry, in religion. Law is one of those professions that is looked at as something you're called due to public interest. You want to help the society, you want to help people. So if you belong to a learned profession, then usually the society or the public will look at you with a different lens. They will look at you with a different lens. And that is what led to the introduction of the professional ethics unit in KSL, because you're supposed to be taught to act like you're a member of the profession and not someone who's out there to do trade. Okay, so how are learned professions characterized? Number one, which this applies to you, the need for unusual learning. To be honest, most of the people who joined campus with you are already working. They are already working, but you had to finish your 4 or 4.5 years or 5 for those who are doing, the regular system. You finish those years, and then you're still required to go to KSL, and then you're required to go for pupillage for 6 months, and then after that you have to wait to be admitted. Okay, you have to wait to be admitted to the High Court. And then after you're admitted, that is when you get a practicing certificate. And even after getting that practicing certificate, each year, you're supposed to do continuous professional development. And these are courses that you do to check the profession, to ensure that the quality of the profession is not watered down. So that need for unusual learning, that one is a characteristic of a profession. I want you to think of yourself. How long have you been waiting to be an advocate of the High Court of Kenya? You've been waiting for some time now. And if you took a break between your undergraduate and KSL, you're already feeling the impact. You feel like nimekaa shule sana, okay? So that's one of the characteristics. And the next one is the need for confidential relationships and a standard of ethics higher than that of the marketplace, okay? You know that under the Advocates Act, and under the Evidence Act, one of the things that is supposed to preserve is the confidentiality. Okay? The confidentiality or the confidential relationship between you and your client. And as a comparison, I just want to let you know that the same applies to doctors. Doctors cannot reveal information about a client, right? They cannot reveal a patient's information. They take the Hippocratic oath. And this also applies to priests. When you go to the confession box and you confess your sin, the priest they're allowed immunity. They cannot even be forced by the court, subpoenaed to testify against you unless in very special circumstances. For you as an advocate, if what the client has revealed to you will further an illegality, then that is the point where you will have to break the confidentiality, because you have a higher duty, which is your duty to the court under Section 55 of the Advocates Act. Okay, so let's look at another characteristic of a profession. We have a professional body, the Law Society of Kenya, okay? So when you become an advocate, you will be enrolled into a record. You'll have a record. You'll be on the record. And that record will give you something called a PC number, okay? So each year, PC is practicing certificate. Is someone speaking? If someone wants to ask something, then let me just know. Okay, then mute your mic, please, so that we continue because of time. So you will be given a practicing certificate and you will be given a PC number. For those of us who are outside, those who are outside, they already have a PC number. It goes by year, okay? Year of admission, and then there are other characters over there. If you haven't seen any, and this is time after the exams, take your time and look at, say, a famous person's, a famous lawyer's PC. Some information is just out there in the general public. Sometimes you're just able to see people's practicing certificate number and the practicing certificate and when they were admitted. So these are the characteristics of a profession, okay? Of a profession. We've said unusual learning. We've said confidential relationships, okay? We've said there will be a professional body, which for us, it's the Law Society of Kenya, okay? And what other characteristics are there of a profession? We have restrictions. Restrictions. Look at the entry requirements. What people are allowed to practice under Section 13 of the Advocates Act, okay? You first have to be admitted to the bar, okay? And you have to have a degree from a recognized university, a degree recognized in, a university recognized in Kenya. You have to have that degree. And then for people from East Africa, say Tanzania, Uganda, Burundi, then those people are allowed to, but they have to come and a special exam will be administered to them. This is discretionary, okay? CLE and LSK will work together to decide what do we do for this person, okay? So there's the restrictions. There's also the restrictions that people without practicing certificates cannot sign instruments or documents. And when you look at the Wilson Dolo Aya case, Wilson Dolo Aya case, this person, this advocate, signed, the advocate was called Violet, signed documents and she did not have an active practicing certificate. She had not renewed. And so what happened in that case? Wilson just, they poked holes into that case and said, you know what, of course, we owe this bank this amount of money, but Violet is not qualified. Violet was not qualified to sign a charge document. Violet was not qualified to sign this and this document. And so Violet had to indemnify the bank, okay? The law firm had to indemnify the bank. So you're looking at those things like restrictions in the profession. And then even as there are restrictions, there will always be regulation of performance. There will be regulation of performance. Anytime that you do something that is unauthorized, anytime that you do you take place in unauthorized practice, then there are sanctions. There are consequences. Your performance is being regulated. We are not talking about a tailor here mwenye ataka na nguo yako 3 months and there's nothing you can do. Unaenda kumbembeleza ama unaenda na polisi ama you go and take your material and say wacha ikae. For advocates, we answer to the structures that are placed there to regulate our performances, okay? So if we are going to look at issues of regulation of performance, then you can look at cases like Rondell versus Worsley, because it is one case that talks about the protection of officers of the court, okay? They can get immunity in some instances. And we will talk about that later on. We will talk about that later on in our slides as we proceed. And Ben, I just want us to define the relationships that can exist between an advocate and a client. There can be a trustee and a beneficiary relationship. There can be a principal and an agent relationship. There can be a guardian and a ward. There can be an attorney and a client relationship. These relationships are usually, it depends on the field that you're dealing with, okay? So that's another characteristic of a profession. You will have a fiduciary relationship where you owe a duty to someone and you owe them a duty to act, to represent them, to act in good faith, to ensure you do due diligence, duty of care, duty to inform them on time, duty to, ensure that you achieve the outcome that they desired. And if you're not able to achieve it, to just explain it to them in a way that they understand, okay? So I don't see a lot to do with this topic one that we have to cover right now. I think so far we've talked about the profession being regulated, you being admitted in the role of advocates, okay? You'll be enrolled in the role of advocates. And then, of course, there are laws that will guide you. There's the LSK Act, there's the SOPEX, there's the Advocate Act, there's the Advocate Remuneration Rules. We have a myriad of a lot of framework that will guide the profession. And this is the point where I invite us to look at it one step at a time. If I am going very, very, very fast, let me know. But I'm trying to ensure that I mention the points that you need tomorrow, the pointers that you need tomorrow, and briefly just try to explain them so that you are in a good place tomorrow, okay? So there's usually this question. Mtu atakuuliza, let me say it in Swahili. And for those from East African countries that do not speak the Swahili dialect, I'll still bring it into perspective in a few seconds, okay? People ask, mbona lawyers wanatetea watu wameua? Why should a lawyer defend someone who's killed someone, okay? And these are ethical questions. These are moral questions. They are guided by our morality. They are guided by the fact that our law springs from morality and religion. And the simple answer is this before we can go far and tackle this PowerPoint over here. The simple answer is under fair trial, no person shall be condemned unheard. I want you to remember Article 50, okay? What is Article 50 of your Constitution? It is the right to fair hearing. So when someone asks you, can a lawyer be a good person? Then there is an ethical dilemma there. There is moral decisions to grapple with. There is religion, and there'll be a lot of arguments coming from different people. Of course, people from the religious perspective will say that lawyers might not go to heaven, okay? Because you are in a profession that involves deceiving people, trickery. You might withhold information, okay? The client comes and tells you, enyewe ni hivi na hivi, lakini mimi nataka unitoe kwa hii story, okay? As long as they are not furthering an illegality, okay? They're not telling you to do something that is illegal. Mutava Kamene, your hand is up. Please speak. Mutava Kamene, did you want to speak? Can we reserve raising hands for later unless you cannot hear me or you cannot see the PowerPoint so that we can take advantage of time. Okay, thank you so much. So someone will tell you, hey, this lawyer, they know they are withholding information. They are working with terrible people. We know that person. That person usually kills people. But the answer is, what is the answer? For this lawyer to decide to uphold confidentiality, for this lawyer to withhold information, for this lawyer to act the way they are acting, even using procedural trickery, because sometimes they will cross-examine a client, a witness, just to water down the case. And the witness could be truthful. But they are confusing this witness in cross-examination just to water down the case so that they can do the duty they owe to their client, okay? So when you're asked such questions, then you will look at law differently. You might want to separate the ethical issues of law from the ethical issues in real life. Why? Because the tenet that governs us here is Article 50, because that is the supreme law of the land, the Constitution, okay? The right to fair trial, okay? So what is moral is not what is always just, okay? What is moral? You're looking at it from a moral lens, from a moral perspective. But it is not usually what is just, because a lawyer will come and they will come with a defense, a good defense that will beat the moral reasoning or the moral arguing of the opposing party, okay? And this is the point that I was saying, that lawyers sometimes may cross-examine a truthful witness, and they're just watering down the case, and then the judge will think, maybe this witness is not credible, or maybe this other side has not met the threshold, and so whatever they were looking to prove has not been, if it's criminal, it has not been proven beyond reasonable doubts, okay? And then if we are weighing the issue of balance of probabilities, then the presiding officer will say, yeah, if I look at this and if I look at the witnesses that were brought, then maybe this side has it. This side takes the day. So what is what is moral is not what is always just. And then lawyers may be required to cross-examine a truthful witness to water down the case. And then lawyers may keep information secret that, if disclosed, may prevent further injury to others. Because under Section 134 and 137 of the Evidence Act, you owe your client a duty of confidentiality, okay? And then you owe them a duty to protect their information. So we are looking at the client advocate-client privilege and confidentiality, okay? So you're protected. You're protected in a manner that you're supposed to keep their information secret. And people will look at it and say, lawyers are bad. Lawyers are not moral. No, you have to separate morality and justice and say that in the quest of justice, a lot of things change. A lot of things change, and we have laws for that. So under the law, if they are just, then that is just the law as is. So those ethical dilemmas, those moral dilemmas that you're faced with will have to be separated from the law. And then sometimes you see that lawyers may take up a cause of an unworthy client, okay? So you are looking at this client and you're saying, I see all the evidence leads to this person. But you must remember that every person has the right to representation, okay? To the extent in some criminal cases, the court, the state, at its own expense, will get some person's representation. And that is called pro bono services, okay? Pro bono services under Legal Aid Act and also under Article 49 and 50 of the Constitution. You have a right to have legal representation, because at any point, if it appears that you were prejudiced because you did not get legal representation, then that's the end. That's the end of that case. Okay, if you're prejudiced, then other measures have to be taken, which of course you are aware of this in your civil and criminal. I will not belabor with that. Okay. So after we've looked at that, let's look at one thing that is very important. I've been telling you to read this act. For those of you who got around to read the LSK Act, I hope that you got something from it. But if you've been too busy, you've not been able to go through the act, then I understand. Do not lose sleep over it. So I will stop sharing so that I can share the LSK Act. And if you're anywhere near the LSK Act, then help me look at it. Help me look at it so that we can see how it is established. I'm just trying to see where the act is. Trying to see where the act is. LSK Act. I'll just have to look for another one very fast. Let's look at the Law Society of Kenya Act, because it's very important that we familiarize ourselves with the act today. This is not exactly what I'm looking for. Yeah, it's this one. It's this one. It's this one over here. Okay. So let's look at it very fast. So I want you to look at section 3. Okay. I want you to look at section 3. Section 3 is the establishment of the Law Society of Kenya. Okay. Section 3 is the establishment of the Law Society of Kenya. And so when it is established as a body corporate. And you know the characteristics of a body corporate. And in this case, Law Society of Kenya, we'll call it LSK, can sue and be sued, okay? It can take, purchase, hold property, whether movable or removable. It can borrow or raise money, because a question will come asking you about the powers of the Law Society of Kenya, okay? And they have a wide range of powers. So it's best to start with section 3, where it is established. And how is it being established? It is being established as a body corporate. What are the powers that it has as a body corporate? It can sue and it can be sued. It can buy, own, hold property, whether movable and immovable. It can borrow and raise money, and it can invest and deal with monies of the society. Because remember, for your practicing certificates, you pay. That is one of the ways in which the society is able to run its affairs. You pay for such services. So it is able to invest and deal with monies of the society as determined by the society. And then there are other acts which it performs, okay? There are other acts which it performs. So let's look at section 4 to get a clear picture of the functions and objects of the LSK. And the first one, they assist the government and the courts in matters relating to legislation, administration of justice, and practice of law in Kenya. I know for sure, and I can bet on this, that at some point you have seen cases in court where LSK is amicus curiae, okay? Whether you want to say it amicus curiae, pronunciation is personal, but you've seen them. Why are they coming there? As a friend of the court. They are coming to help the court in explaining matters of the law, okay? They're coming to explain matters of the law. And another function of the LSK is uphold the Constitution of Kenya and advance the rule of law and the administration of justice. If you want to know that the LSK is powerful, I want you to remember the time that the Occupy Parliament hashtag was going on and Gen Z was all over the street and people were being killed, extrajudicial killings. You saw the president. Is not the president of the LSK, Madam Faith Moni, calling upon the government to stop the extrajudicial killings, among other things. Okay, so it upholds the Constitution of Kenya, and of course, she was just talking on the Bill of Rights. Okay, the Bill of Rights, and then another thing that they do is ensure that all people who practice law in Kenya or provide legal services in Kenya meet the standards of learning, professional competence, and professional conduct that are appropriate for the legal services. So let me tell you what they do. The moment you finish your CLE exams, okay, and you get your 9Ps and you have your qualification for pupillage, then once you're being admitted to your bar, then your name is added to the roll of advocates, okay? It doesn't stop there. They will still give you CPD, continuous professional development exams every year, okay? In order to add you score 5 marks or 5 units in order to be given a practicing certificate. And there are a lot of things you do. You can go for seminars. It could be a research paper. It could be some pro bono work you've done for you to get this CPD points, okay? It doesn't stop there. Anytime you misbehave, there is professional incompetence or professional misconduct coming from you, then you will be subjected to the Advocates Complaint Commission. Okay? And then the Advocate Complaints Commission will say, this matter, we are dismissing it because it does not hold water, or this matter, we have decided, let it go to ADR, or no, this is a matter that should be listened to beyond ADR. So what are we doing? We are sending it to the Advocates Disciplinary Tribunal. Who do you think that does that? That is the role of the LSK, okay? Another thing the LSK does that you may not know is that it protects the members of the public, vibaya sana. And that one also ties to the issue of extrajudicial killing. And it also protects you. You are a member of the public when you're not being an advocate, okay? So it protects you. And if you want to know that it protects you, you remember the case, 2016 case of Willie Kimani, the lawyer who was killed by the police, Frederick Olele Kiman. And the Law Society had a lot to say because this police was this advocate was an advocate of IPOA, and they were being protected, and the client was also being protected by the police because of just abuse of powers, decided to kill this advocate. So the LSK protects you as an advocate, and they set the standards of learning. Where do you think SOPEC came from? Those are some of the roles or functions that when you think of LSK, you have to think of. The person who's not muted your mic, please mute your mic. It's distracting, okay? And then it will enhance, of course, those standards. We've talked about SOPEC. It will facilitate the acquisition of legal knowledge by members, okay? It will ensure CLE is being run well. It will ensure that KSL is being run well. It will ensure that no one is abusing the rules of the practice or anything that connects to law at the undergraduate level, and that there's a syllabus to be adhered to, okay? So what else does it do? Represent, protect, and assist members of the legal profession. We have done so many of these. I would wish to move on because if you look at the role of LSK, hawezi kosa tano, hata hawezi kosa saba, okay? You will have at least 7 to take you through. So what are the general powers of the society. What are the general powers of the society? Of course, when we look at some things like we have guiding principles, of course, they maintain and advance constitutionalism, justice, the rule of law, justice, public interest, access to justice. We usually have the legal aid week, and this is for the public. And LSK is usually Hukombele at the front line working with private entities like Katiba Institute, okay? They hear something about the public, they are out there. They ensure that there is access to justice. They ensure that you are professional and you're maintaining your integrity. That is why we have the Advocates Complaint Commission and the Advocates Disciplinary Tribunal, okay? And they also promote cross-border legal practice, inclusivity, and equity. We talked about persons from East Africa being allowed to practice in Kenya under some conditions, okay? If you look at your Advocates Act, just from Section 9 all the way to Section 15, you will understand what I am saying. So who are the members of this society? And of course, we have a society. Society is you the day you will be admitted. I am seeing 382 people in this class. You will be admitted, inshallah. You will be admitted next year at some point, maybe March or June, okay? Once your name has been entered into that role of advocate, you become a member of the society, okay? Do not forget that. Do not forget you being a member when your name is admitted to the role of advocates, okay? And of course, we have other people. We have the senior councils. We have the honorary members of the society. They will be admitted. But the main person who becomes a member is you the moment you're admitted and enrolled in the role of advocates. And then we have a special membership. And this special membership now is the one for the senior council. If you look at Section 10, okay? If you look at Section 10, then this is those people come in there, the registrar, kina nani, watakuja hapo chini, okay? Then, after we've done that, we've seen now the membership. Let's look at other people in the society. Of course, there's issues for termination of membership, and you know those ones you can be suspended or expelled because of professional misconduct. Okay. The other person is now the people, the governance of the society. Okay. Number one, we are going to look at the organs of the council and the governance of the society. We have organs of the council. And who are these? Number one, the general meeting. Number two, the council. Number three, the secretariat. And number four, the branches. Okay? Those four. Kumbuka, general meeting, council, secretariat, and branches. Who is the general meeting? Who is the general meeting? This one is seen as the supreme authority of the society. Okay? And this general meeting is you. This general meeting is you. All the members of the society. Wanaitwa general meetings. Okay? Wanaitwa general meeting. All the members of the society. And then now, under those organs, we have the second person with the council. This body, the council. Who is the body? We have the president. We have the vice president. Okay? President, vice president. And then unaona ile general membership yenye nimekuambia, it's everyone. They will go there and pick 3 members. They will go to the general meeting and pick 3 members, the general membership. After they pick 3 members, now one of those members has to be an advocate of at least 25 years standing. This is an advocate who's been in and out of every court. They have the know-how. They know everything about the law. And I'd give an example with counsel senior Hamino, okay? He's not senior counsel. Okay, I'll give an example with him. That person would be someone who would fit in the general membership very well. He has more than 25 years of experience practicing law. Okay, so we have the president, we have the vice president, we have 3 representatives, one of whom has practiced for at least 25 years. Then after that, they'll take 4 up-country representatives. We don't want anyone from Nairobi or Coast. Other counties, okay? Those 45 counties, we want 4 up-country representatives, okay? They pick them. They say, hatuchukui Nairobi, wala hatuchukui Mombasa. We want 4. So now who do we have? We have the president, the vice president. We have 3 representatives, one of 25 years standing. And then now we've taken 4 up-country representative. None is in Nairobi, none is in Coast kwa watu. Then we say sasa tumeshachukua up-country. Now, let's pick 3 in Nairobi. 3 practicing in Nairobi, okay? And then 1 practicing in Coast. I hope so far unanipata. So we have 1 in Coast, 3 in Nairobi, those are 4. 4 up country, those are 8. 3 representative, those are 11. 1 of 25 years standing, okay? And then we have the vice president, 12, and the president, 13. I hope that you can remember some, if not, all of that. So what is the eligibility for you to be elected as a member of the council? I scrolled so fast. I'm sorry about that. To be elected as a president or a vice president, you have to be a member or a former member of the council, okay? You have to be, you see how Faith Moni became president so easily of the LSK? She used to be the deputy to George Deuri, okay, to George Deuri. So it was very easy because she was a former member of the council, okay? And then you have to be qualified to be a judge of the Supreme Court. For you to be what? For you to be elected as a president or a vice president, kumbuka tu mbili, lazima ukuwe na powers kama the 7 judges in the Supreme Court. Think of kina Martha Koome, think of kina Philomena Mwilu, think of kina Njoki Ndung'u. You have to possess their qualifications. And their qualifications to become a judge of the Supreme Court under Article 163 of your Constitution, okay? So, and then you have to be a member or a former member of the council, okay? And then for you to be elected, as a member of the council, now this is not the president or the vice president. This is those 3 representatives, 1 of 25 years standing, 4 representatives from up country, 3 from Nairobi, and 1 from Coast. What are the qualifications? You have to be a member of the society, okay? And then you have to have been in practice for at least 2 years from the date of admission. And then you have to not have been found liable for professional misconduct. Umepelekwa huko mbele ya disciplinary committee because you're harassing clients or you're harassing fellow lawyers, your peers in the corridors, or you're being rude to the judge over there. So you have to be a member of good standing. Of course, Chapter 6 of the Constitution is a requirement that you must meet, okay? So how does the election happen? There's the election of the president, the election of the vice president, and the members of the council. Of course, election is usually elections usually happen in a transparent manner by secret ballot, and then every second year we did the election for LSK this year. Mwezi wa ngapi? I think ilikuwa mwezi wa 3 ama mwezi wa 4. Correct me if I'm wrong. Mwezi wa pili, around there, okay? So what happens is 2 years from February 2024, there will be another election, okay? And it will be by secret ballot. It has to be transparent and fair after 2 years, and it is conducted on the same day by the members physically present, okay? And then, of course, you know that the president will assume the office, and then they'll hold it for 2 years, of course. If the election is to be conducted after 2 years, it means that this office will be held for 2 years, okay? Now, if you're elected as a president, you can only serve for 1 term. If you're elected as a president, you can only serve for 1 term. But a vice president can vie as a president. I hope you are able to see. I hope you're able to see the difference, because I just want to conclude this so that we move on. Of course, removal of office. Usiwahi sahau kitu kama bankruptcy. This individual, of course, they can be suspended or expelled. Those ones are no-brainers. Go for those easy ones first, okay? Mental or physical infirmity. This means that they lack capacity. think of those, and then think of failure to attend 4 consecutive council meetings without reasonable grounds accepted by the council. There's a time Harvey was about to be removed from office because he was not attending meetings, okay? Nelson Harvey. So think of those situations that have been there in the past, real life situations, and you will see when the people that have taught LWD, when I tell you to go through this act, I usually tell you what this act is very easy. It's easy to ingest, and it tells you a lot that you need to know about how an act should be, and also you see that it is really explaining LSK society for us, okay? So what are the branches? Branches used to be, they were divided according to provinces. Of course, we used to have provinces, now we have counties. So there is Coast, there is Rift Valley, and then Rift Valley is divided into 2. There is North Rift, because the moment you finish Naivasha and Nakuru, when you go inside into Kabarak, Ravine, Mogotio, Baringo, those who know what I'm talking about, Iten, Marakwet, then that is North Rift, okay? And Eldoret. And then there was West Kenya and there was Southwest Kenya. Then there's Mount Kenya, Southeastern, and Nairobi, okay? So there are branches of the society. Do not think that the only branch that is there is the one in Lavington. There are other branches in Mombasa, and there are other, in fact, Mombasa is an old one. Mombasa is an old one when the Law Society of Kenya was being established, okay? So I just wanted to look at the role of the secretary, and then we move on to something else. Now, there shall be a secretary to the council who shall be the chief executive of the society and in charge of the secretariat of the society, okay? So if you hear chief executive of the society and the person in charge of the secretariat, usiseme huyu ni president or LSK. This is the secretary, okay? And this secretary is not elected. You see, we have elected the president, Tukoju. We have elected the vice president. We have elected the 4 members from up country, okay? We have elected the 3 members from Nairobi. We have elected the 3 members, one of 25 years standing. And we have also elected 1 member from Coast. Now we are appointing the secretary, okay? And the secretary is the one who's responsible to the day-to-day running of the affairs and functions of the society, okay? So what is the eligibility of being appointed? Remember, secretary is not elected, they're appointed. You have to be an advocate of the High Court of Kenya with at least 10 years experience, and you meet the requirement of Chapter 6 of the Constitution. That is LSK Act for you in a nutshell. If you can remember 1 or 2 things there, because it is a possible question that might come. If you can remember 1 or 2 things, then we are good. And just like any society, just like any corporate body, they have ordinary meetings, okay? They have ordinary meetings, and they also usually have special general meetings. They usually have special general meetings. And when you find 5 minutes of your daily and unapitia leo ya mwisho so that you're ready for tomorrow, I just want you to go through this act. See, it's 19 pages, and you're supposed to read a minimum of 7 pages to understand it. You're supposed to read a minimum of 7 pages to understand it. So I'm going to stop sharing so that I go back to our normal topics, and now we are going to go very fast because we are going to look at things like duties of advocates and what have you, and this one should be easy, okay? Easy like Sunday morning. I want this to go so that we've done. Someone is talking, please mute your mic. I want this thing to go. Where does I want this thing to go so that I'm able to access the PowerPoint? How do I remove it? Someone mute that mic, please. Is that Claire or Mary? Claire? Claire? Claire, is someone able to mute? Am I able to mute?
crash session. Yeah, na crash teach. Yeah, let's join the difference scope and join the two group.
Where Claire Omari? Claire?
Kuna
Claire?
napatanga nimebaki kufuzi nikiada na app.
Is someone
Na
able to
sisi
call
yangu
her?
different.
Is there a classmate?
Ni different.
Please call Claire Omari
Mwalimu.
and tell them, yes?
Toa yeye mwalimu.
Mine are different.
I don't have the powers.
Beautiful.
Kumtoa, senior has the
Kuna
powers.
tunatafuta na na yes.
And it seems like she's not even attending the class because she's talking in the background. Anyway, it's up to her. Claire. Claire. Oh
Sasa anaweza
no.
kuwa ananipigia jirani.
Claire,
Hello.
someone able to
Sasa? What the fuck?
Who knows where she stays in Mpata?
You can mute her.
I'm not able to. It's only senior who has the power. My powers have been limited to. My powers have been limited to Nini. What is it called? I'm only able to present at this particular time. I think she has muted or she has been. Thanks. If someone had to call her, thank you so much for taking one for the team. Claire, you've been really disruptive. I want you to pay attention or, just figure it out. You have a very small window up to tomorrow. And I hope I'm not being hard on you, but please, you concentrate kidogo tu, upate kidogo chako, and then you'll be on your way out and you'll be good. Okay? I want you to be an advocate, Claire. I'm your friend. We're on the same side. So let's look at duties of lawyers, okay? So what are duties of lawyers to the profession and opposing advocates? Number one, duty of fairness, okay? You're supposed to be just, impartial, free of bias or prejudice, okay? Duty of courtesy and respect. Ukwe tu na heshima tu kwa watu. Because name holds weight like kilo. I usually say this. You will not know how a name holds weight until someone's reputation is at stake, okay? Then there's duty to courtesy and respect, which I've mentioned. That one should go with your name, okay? Duty of honesty and fair dealings. Avoid sharp practice. Hii maneno ya kimbiza pesa haraka, get rich quick, it really comes to bite you in the end, in the long run, okay? So you have to be honest and make sure that all your dealings are fair. You do what any reasonable man in your place would have done if they were presented with the same situation, okay? So fair dealings, also duty to cooperation. Try and cooperate with the opposing side. Do not write threats and foul words in a demand letter. Try to cooperate. Basic structure doctrine. Try and promote a DR. Let's solve these things amicably because many wars have been won on corridors than in the court itself, okay? So when you're dealing with opposing advocates and you're dealing with your client, and you are cooperating and you're promoting ADR, I'll call Kerubo Violet and I'll tell Kerubo, hey, wakili, where are you? EKC, badala tupeleke kotini. We have been given power to promote ADR. Let's ask these parties if they want to go through ADR. Kwanza, they try and solve this story. Ikishindikana, then we can come back to the litigation process. But first, let's see if we can do mediation. But some of us are too selfish. We want to prolong court processes and to pata pesa mingi. We want a lot of money. The desire for profits. Inafanya, we lose that duty to cooperation, and we also in the process lose our relations with senior colleagues and relations to junior colleagues. And when it comes to relations with senior colleagues, I want you to borrow a leaf from me. You've noticed when I'm talking to senior, I address him as senior, okay? Because he is a senior colleague to me, okay? And then when I'm talking to you, okay, when I'm talking to you, if we ever run into each other in the corridors of justice or wherever, I will not call you junior, but I will have the duty to show you around, the duty to guide you, the duty to be your peer, the duty to maybe work with you and show you, this has worked before. if you're asking for my advice, or I tell you, Wakili, can we try mediation? Okay, so you have a duty. You have a duty to both your junior and your senior colleagues, and you're supposed to remember them. And then what is your duty to the court? Of course, always, 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 always act in good faith. Always act in good faith, okay? You owe a duty to the court. And if you look at Section 55 of the Advocates Act, when your duty to client, okay, it looks like it's going to be compromised when the client tells you something that says furthers an illegality, then what are you supposed to do? Your duty to court will override the duty to client. So anytime they mention duty to court, I want you to remember Section 55 of the Advocates Act, and I want you to remember Rondell versus Worsley. Advocates are officers of the court. That is Section 55 of the Advocates Act. So anytime a client tells you, hey, hebu tuende tufiche hii pesa mahali. You remember the case of Tomogenda? The case of Tomogenda and Mumia's Sugar. When a client tells you something that furthers an illegality, then your duty to court will override your duty to the client, okay? And then, of course, we've talked about the duty to act in good faith, okay? And then you, as an advocate, must not mislead the court. You go there and start casting aspersions. People will read you. People will see right through you. And they will see that you are not doing your duty to court. You're misleading the court, okay? And that is a professional misconduct. And then you have to have a duty of fairness. Be fair to the opposing side. Be fair to the judge who's trying to get things done. There was a video going round of an advocate who was really someaing the judge, read the judge to filth. As much as, and hear me out, I felt like their rights kidogo alikuwa anajitetea, he was right. I also felt like that was not the venue of forum, because the issue of the public upholds the legal profession in oath. Huyo ni lawyer, huyo mtu ni lawyer. So be fair, okay? Be fair, and then also be impartial. Be impartial. Usionyeshe you're biased. Even if you're in the seat of a presiding officer or a magistrate, be impartial. Be neutral. We will look at Bangalore principles, and you will see why it is important to be impartial. Because the moment you take sides, the moment there's conflict of interest, then that case is dead on arrival, okay? That case is dead on arrival. You also have a duty to obey court orders, okay? Otherwise, utashikwa hapo story ya contempt of court. Wewe unaambiwa nyamaza pale kotini, unataka tu kubishana. Unaambiwa nyamaza, you have a duty to obey court orders because you swore an oath, you took an oath. You took an oath when you're being admitted as an advocate of the High Court of Kenya, and you said you're going to do your duty to uphold justice, nini. You have a duty, okay? Then you have a duty to the law, always follow the law, work within the confines of law. Make sure that someone is not sent to jail who is innocent because you decided to break your duty to the law. Your allegiance is to the law, okay? Do not commit fraud on the court. Oh, my letter papers up, they've been cooked. You're hiding evidence, okay? You're giving false statements to the court. You're dragging the character of an innocent person in mud. Do not do that, because your duty to the court overrides your duty to the client. Section 55 of the Advocates Act. What else should happen? Do not publicize ongoing trials. That girl from X who says Kenya ni yetu, the one who read Akina Mandago to filth the other day, the ones who had to go to Australia, they had been sponsored, but Akina Mandago ate their money. You know, they had a case. She was held in contempt of court pale Nakuru because she was publicizing ongoing trials. I want you to remember that that is one element of contempt of court, okay? I also want you to remember that during the BBI ruling, senior counsel, Ahmed Abdi Nasir, then there was Nelson Harvey, and there was Esther Angoya. They were on Twitter. That time it wasn't being called X, it was called Twitter. And they were publicizing BBI. They're saying, mtoto wa Uhuru, ata Supreme Court will be bribed by President Uhuru, and then they will do this, because Supreme Court is just a panel of headless chickens and nini. And Martha Koome called them out, okay? Martha Koome called them out and saying they are undermining the courts. They are undermining the judiciary. So do not publicize ongoing trials, okay? And then you have duty to prosecute matters expeditiously. And here I want to talk about the oxygen principle, okay? Overriding objective. And Article 159 2D, justice shall be delivered without undue regard to procedural technicalities. And if you go further under Article 159, you will see ADR is an option provided there. If you go to Section 1, A, B, and 3 of the Civil Procedure Act, it's the overriding objectives where courts and everyone shall ensure that matters that they are prosecuted, that matters proceed in a manner that is just, fair, expeditious, okay? And justice shall not be delayed, okay? Justice shall not be delayed. It shall be delivered without undue regard to procedural technicalities. And you, as an advocate, has a role there to ensure that these matters are prosecuted expeditiously. You're supposed to give a submission. Don't come saying, I was not ready, or this. You keep postponing cases so that you can have your way. You keep advising the client to abscond court so that you can delay the case even further and create a backlog in the court process. You also have a duty of respect. You're supposed to act in a dignified manner. And let me tell you something about duties of an advocate. They are all over there. You can even guess 5 of them. And you will be okay. You will just be okay. Utakuwa umezipata na uko tu sawa. Then you have a duty to public, which is of course the duty to act in good faith. Ukiwa pale uko, wewe ndio unatu represent. You hold our name out there. Then duty to fairness, okay? Duty to fairness. And what else do we have? I just want to give you a side note, which is neither here or there, but since you're finishing, why are you called an advocate of the High Court of Kenya and not any other court, okay? So historically, I want you to remember when the legal profession progressed, lawyers would take oaths to be admitted to relevant jurisdictions. In Kenya, it is the High Court because it has unlimited original jurisdiction for criminal and civil matters. So I want to tell you that the Supreme Court was created in 2010. The Court of Appeal, its jurisdiction is to take appeals from the High Court, okay? The other jurisdiction they have is maybe to hold you in contempt of court, issues to deal with contempt of court. But High Court has been the court, superior court, the court with unlimited criminal and civil jurisdiction. And that is why when you're being admitted, you will be admitted in a place where you can work without your jurisdiction being limited, as it has been limited in subordinate courts, as it has been limited in Supreme Court, as it has been limited in Court of Appeal, because Supreme Court is majorly a constitutional court, and you know what it deals with, okay? So this High Court is where you can do everything. You can do all those units you've learned in your life, because there is an limited original jurisdiction for criminal and civil matters. I hope that helps you today. So someone asks you, why are you an advocate of the High Court and not Supreme Court? That is your answer, okay? So what is the duty to client? Hii usisahau, confidentiality. And confidentiality, I've seen people writing papers and sending to me, mwalimu niangalilie hii. You're writing section 134 and 137 of the Advocates Act. It's not Advocates Act, it's Evidence Act, okay? It's a common mistake, anyone can make it. But I want you to remember that it is Evidence Act and not Advocates Act, okay? And then section 2. What is section 2? Section 2 of the Advocates Act defines a client. What does it say? It includes someone who's about to retain or employ an advocate, okay? So it's someone who has retained an advocate, employed an advocate, or someone who is about to. Where am I headed? I'm headed to the place where I'm telling you your duty to client. Client akikuja kwako leo akwambie, now mimi wanasema mimi nilifanya hivi na hivi, lakini mimi sikufanya hivyo kwa sababu say ni sexual offense case, kulikuwa na consent, okay? Kulikuwa na consent. And then tomorrow the client decides that they do not want you to represent them, so they don't pay you the retainer, so they go to another advocate. Sasa wewe usiende pale nje and then you start talking. And I saw that the other day with Harvey. I'm putting you in real life circumstances because you're doing the exam tomorrow. I hope this is easier on you. I want to go easy on you. Harvey wrote about the people who sold Sirona Hotel for millions. And then they wanted to retain Harvey. And Harvey talked over a drink with, is it Gitobu Imanyara? Kamwambia wewe watu wachana na wao ni gone case. Then a few days later, a Mercedes-Benz was found. They had rained it with bullets. And the advocate and the people who had sold Sirona Hotel were dead. Under Section 2 of the Advocates Act defining a client, under Section 134 and 137 of the Evidence Act, Nelson Harvey broke the duty to a client, which is the duty of confidentiality. Okay, and it is born. Its mother is Article 31, the right to privacy. Okay, I hope that helps. Moving on, of course, you have SOPEC, which also speaks to the duty to confidentiality. SOPEC 7, your communication must be privileged. And even after the engagement ends, your communication must be privileged, okay? And I'll give you a case law, Okotobado versus Wajakoya, Okotobado and two others versus Wajakoya. The time Sharon was killed, the Migori student Sharon Otieno, what happened is Wajakoya rushed to Gigiri police station where Okotobado was being held. He rushed there and he told Wajakoya, you know what? He told Obado, you know what? I got you. Dude, I got you. So Wajakoya told him, hey, even ndio kunaenda. Then later on, Wajakoya thought it wise to engage another advocate, okay? Two other advocates. So this means that Obado was not going to be retained. So what happened? Obado, feeling the pinch of not getting the money for such a high profile case, not Obado, Wajakoya, sorry. Wajakoya, this Luchiri Wajakoya, went to Sharon's family. Kambia Mama Sharon, unajua nini? Your daughter has been killed. I want you to represent your family. And the first thing the lawyers that had been instructed by Obado did is they went to court to stop Luchiri Wajakoya from representing Sharon's family, because the duty of confidentiality was going to be broken, and there was also going to be an issue of conflict of interest. So I've told you about, of course, confidentiality and privilege. And then we've talked about Tomo Gender versus EACC. This is Tomo Gender as a lawyer of Mumias. This was the time for, if you ever hear Kidero, people say Kidero stole from Mumias, allegedly. Don't quote me on that. This was that time. Tomogenda was holding proceeds that were believed to be from Mumia's, crime proceeds that Kidero had allegedly stolen. Tomogenda was holding in a Barclays Bank in Nakuru, in his account, advocate's account, okay? So these things repeat themselves. You will see that something to do with confidentiality will coincide with something to do with conflict of interest. And I want you to just remember what matters for you, what you can use tomorrow. Now you have the duty to fiercely and zealously represent the client. And I want to take you in a real life setup yenye happened juzi. Did you see how Counsel Elisha Ongoya was defending Gachagua, Rigathi Gachagua, former vice president? That is fiercely and zealously representing the client. I'm not going to say anything after that. I'm just going to leave it there because that man really made my, weekday, whatever, okay? So you also have a duty to communicate with client, maintain communication, tell them the truth, tell them the merits and demerits of their case, waandikie legal opinion, do them a case brief, do them a case analysis, tell them, is this case holding, hii itaenda kushinda kweli, hii simkutane tu pale tu tukutane pale kwa ile room yangu, ile ofisi yangu, and then alafu tuamue tutalipana pesa ngapi, musi waste time kotini. Use simple language and avoid legalese. Give them enough information. Just make sure your client is informed. When's the next hearing? When's the next representation? When are you required to attend court next? When are you required to do this duty to the opposing side next? Okay? Because if you do not communicate to your advocate, to your client effectively, then it amounts to a professional misconduct. Be also loyal to clients. Be loyal. There was a time I was working in a court setup, and I used to see a lawyer working for both sides, an advocate working for both sides. And it used to hurt me because Why would you study all those years to just come and play for both teams and not in a nice way? You can act for both sides, but always avoid conflict of interest. And of course, in this situation, I could see conflict of interest, okay? And then let the client be able to make decisions. Sema mimi mali imefika nataka ku-withdraw hii kesi. Aliniibia lakini nimeangalia watoto wake wameteseka tangu akae remand Lang'ata. Nataka ku-withdraw. Stop telling the client, hapana, afungwe. Let them make their own decisions. Let them consent to some things. You know, these duties that don't need a lot of it's not rocket science, okay? Then safeguard the client's property. One of client's property you can have is something like titles, okay? Titles for the purpose of maybe transfer or registration of a charge. You can have money. You can have money and you will be a stakeholder holding that money like deposit for land transactions, okay, for transfers, okay. So hold that property in good faith. Do not misuse it, and then be truthful at all times, okay. Be truthful at all times. Of course, we've talked about best interest of the client, and when you talk about best interest of the client, you look at National Bank versus Nani Mungai, and then we also look at King Wool and Mills, okay. King Wool and Mills, we look at those things, cases like those. Charge reasonable fees. Of course, we look at remuneration, retainer and lien hapa mbele. Charge reasonable fees. Wacha tamaa mingi, unakimbia to get some money. And then if a client has not paid you and they're supposed to pay you, you have a duty to represent the client until the conclusion of the case, and then you sue for legal case later. Usiwache client mataani ati ye huyo ana do hiyo kesi hata sina haja nayo. No. What you do, represent them till the end, and then charge you sue for fee later. And there's a case called Pimachira versus James Odera book, okay, where this person said, Apana, I'm not being paid enough for these problems. This client does not even have money, so I'm not going to represent them, okay? So that is a duty that you owe to a client. Charge them reasonable fee, represent them, and then sue for fees later. And then, of course, you have a duty to yourself. Jiheshimu nani. Respect, self-respect, be modest. Do not go there bragging, feeling like you're the lawyer, just the next best thing after sliced bread. No, be just modest, be nice, be kind, dress nicely. There's a guy called Ali Kovan who says, the world will look at you and it will address you the way you are, because it will address you the way you are dressed, okay? So it looks at you, it looks at your clothes and decides hizi nguo zinakaa alitoa kwa mdomo ya ng'ombe asubuhi ndiye akavaa. Okay, you've not ironed your clothes. Okay, you've decided for some reason to wear oversized clothes. Of course, we have economical challenges, but I usually argue that kuwa hata na suti mbili safi yako tu, hata kama ni suti ya mtumba yako safi, pasa, kuna pasi ya makaa, iron that kasuit, show up very clean. Okay, so try and be well dressed, grooming. Okay, if issues to do with the the honesty, candor, and integrity, full disclosure, payment of agreed fee, cooperation, those ones, I think those ones we are good to go so far. I want to just go to the next topic. Of course, when you take instructions, you're supposed to take instructions and make sure you fulfill them, fulfill them like when you give things like professional undertakings, okay? So be truthful, be honest. We talked about candor and integrity. And then what does the Judicial Service Act say for judicial officers? It's same to Bangalore principles. And when we look at Bangalore principles, there are 6. I want you to look at these 6 Bangalore principles, same as Judicial Service Act. They say these principles that you're supposed to abide by. You're supposed to be impartial, okay? You're supposed to be proper. Appropriate is not appropriator, it's proper, okay? And if you look at chapter 6 of the Constitution, you'll see the elements of these things that I'm talking about here. You're supposed to exercise integrity, independence, equality, and transparency. Those 6: impartiality, propriety, integrity, independence, equality, transparency. Make sure you are in good conduct wherever you are. Actually, starting from today, No, I never told you, but I believe you've gone through your professional ethics classes. So I'm just echoing what your teachers have already told you. Just practice to exercise Bangalore principles. The moment you exercise them, and then you go into the topic, no undercutting, okay? You are not overcharging either, okay? You are not touting. You're not lying to your clients. You're acting in good faith, okay? You are avoiding conflict of interest. My friend, you will be a good lawyer. You will be a good man, okay? There's that meme for, as I go to the next slide, there's that meme for, is a good man, Savannah. So if you ever act under the Bangalore principle or judicial service, who's raised their hand? Who's raised your hand? If you've raised your hand, this is the moment when you talk, when I'm presenting the next slide, unmute and speak. But I said if it's okay with you guys, unless it's something that you need me to address very fast, you can wait for me to go towards the conclusion. And then when we are doing the past papers, is when you can raise your hands and ask questions. So let's look at something that I hold dear to my heart. This is called pauper briefs. Pauper briefs. Pauper is a synonym for poor, okay? It's a synonym for poor, or it's a synonym for people who do not have. Pauper in England, if you watch movies from England, you'll see that paupers wanakwanga kiwale watu wanatembea na vikombe ama sahani wakiomba, okay? So the moment you hear pauper briefs, I want you to think poor, okay? The next thing I want you to think of, tomorrow you see pauper brief, think pro bono. Sawa sawa. Think pro bono. Before I go to the slides, I want to tell you, when you're thinking pro bono, what are you thinking about? You're thinking Article 49, right of arrested persons, okay? Ameshikwa. What right do they have? They have a right to a phone call, to call a family member or an advocate. Sawa sawa. Think Article 50. What is Article 50? Fair hearing. What should happen here? The right to representation, okay? Because there will be several reasons why people need representation. Some of them may not understand the gravity of the case. Cases like robbery with violence, murder, cases to do with children. Children, you have to have representation. And if you cannot afford it, one will be provided to you at the state's expense. So now, guys, we've talked about Article 49 and we've talked about Article 50. Where do we go for pauper briefs again? We go to the Legal Aid Act. Legal Aid Act. And I want you to write this section if you don't remember any section from Legal Aid Act. I want you to write section 43. Sawa sawa. We have created an introduction. So now let's dig in. Okay? So why is it important to have a pro bono representation? Why is it important? Of course, if you look at access to justice, before we go to arrested persons in Article 49, pale Article 48 kuna kuanga na access to justice. Kila mtu ako na right. Yeah, this is Bill of Rights. Okay? You have the right to justice, okay, to access justice. Sawa sawa. If at any point it is seen that you were prejudiced, then justice was not served, okay? So it is important that when you cannot afford legal representation, then one be afforded to you or accorded to you at the state's expense. However, it is not for all crimes or civil wrongs that is sasa utapata pro bono. Hapana. It is not a right, at the absolute right. No. And then also you have to apply for it. Okay. You also have to apply to it. You apply for it so that you are given. Okay. So what are the principles that you need to consider here? Of course, we've talked about Article 48, 49, 50. Kumbuka hizo. Then equality before the law. Equality before the law. We are looking at fairness. Fairness. Okay. Then we are looking at human rights. You see this international organization. This international organization, if they find that someone was prejudiced because you refuse to give them representation, especially these groups. Look, Apa, it's women, okay? Hapa CEDAW, hapa it's women. Hapa kwa ISCR, this is economical, social, and cultural, okay? And this is where they look at even people with disabilities. So you will find something like persons with disability of rights here. And then CRC, Committee on Rights of the Child, okay? Maputo Protocol was on women rights in Africa, okay? African Commission on Human Rights, jaribu kunyima mtu representation, Ama you do some extrajudicial killings over there instead of bringing them to court. So human rights is a bigger sphere. It goes beyond national territories. It will go it will go up to international territories. So think of equality before the law. We are trying to give these people access to justice under Article 48, 49, and 50. Okay? And also we are trying to exercise fairness. Our watu wasikwe prejudiced, okay, by the court process. And then we are looking at international laws. Tumepata an alien in Kenya, and we are supposed to extradite them back to their country. Okay, what is the first thing that we will do, because maybe they are speaking Oromo language? We had such a situation in court the other day, so they couldn't understand English. We take them back where we had detained them, which is industrial area. But because we've detained them for quite some time, by tomorrow we will have an interpreter for these people. Bring them back to court tomorrow, so that when we decide they are here illegally, we just take them to JKIA and take them back to their country. Okay, so you should think of human rights, and then feed them, please feed them. Okay. And while we are feeding them, let's also find them a pro bono advocate. Let's find them a pro bono advocate who will represent them, okay? So legal instruments, tumesema, constitution. I want you to think of Article 48, 49, 50, and then you can also think of Article 10. Article 10 in Akwanga, very rich. There you will get a lot of things. You will get democracy, you will get participation of the people, human dignity, equality. You also get Article 27, of course, equality and fairness, okay? And then we get, what else? We get here good governance issues to do with Chapter 6, okay? So at least you have those notes, and they will be coming to you. Overriding objective, of course, Article 159 2D, you think of those. And then what are the statutes? I told you Legal Aid Act, and I told you to write Section 43 now tulie, okay? Section 43 now tulie. So this statute will tell you the process, how you apply for the legal aid, okay? How you apply for it, and how you get it, and how the government sends the advocate to court, and so you get that representation. Who are the people that work for or work through the Legal Aid Act? They are the National Legal Aid Services. I believe that you've heard of these people, the National Legal Aid Services. And who are the beneficiaries? Who are the beneficiaries of pro bono services? Stateless persons. There are people who are stateless, okay? Stateless persons. And then huyo hata ajui nini ilifanyika. There's a time there was war in Yugoslavia before it broke. So these people ilifika mahali, they don't even know where they belong. Wamekimbia hata sasa hawajui wako wapi, okay? And then we have indigent resident of Kenya and citizen. Me and you in trouble with the law, okay? It happens. I'm not saying me and you literally, but it happens. And then refugees under Refugee Act, okay? These Refugees under Refugee Act, I want you to know that these are not enemies. They are not enemies of the country. Si watu wanapigana na Kenya, okay? There are people that are allowed as refugees to be in the country. And then a child. If a case suing a child, okay, ever goes on in court to completion without legal representation, hapo kuna shida, okay? Then we also have victims of human trafficking. We have victims of human trafficking. Of course, under human rights, we're just supposed to take care of them. And then internally displaced persons. Internally displaced persons. So those are the subjects, okay? People who will not be provided for pro bono ni nani? Company. Wewe na shida zako za liquidation. Na za kutaka tufanye alternatives of liquidation. We don't care. We are not giving you legal aid. Okay? We are just going to appoint a liquidator, ashughulike story, okay? Civil society, of course, trust corporations, non-governmental NGO, okay? And then issues that tax. Why do you want us to, you've been evading tax and you want us now to give you pro bono? No, it is not for people like you. This is for children. It is for trafficked persons. It is for refugees. It is for people in trouble with the law, me and you, Kenyan citizens, but it is not for companies. It is not for tax issues. It is not for insolvency. It is not for succession. Okay? So I want you to be able to separate that. Then you said that section 43 that I was talking about. I was saying the accused person has the right to be informed on the right to legal representation. Okay? So this is what they are usually told. If you cannot afford an advocate, one will be provided to you by the court or by the state. Okay? So up to there, I think we have seen the issue of pro bono. And I'll tell you how it happens in court. When you start working in court, kuna kwanga na, hii mwaka, it's Kerubo who did it, okay? Na John wamefanya, na Mary wamefanya, na Janet wamefanya. So far nani hajafanya? Maga. Maga kwanza huwa anaipa hizi kazi kwa sababu zina pesa kidogo. Ebu iteni Maga. So they'll call me and they'll tell me, wherever you're taking that case pro bono, and advocates really like running from this case. And if you're found to have refused a pro bono case, it is a professional misconduct. Okay? It is a professional misconduct. Hawezi kata kesi ya pro bono useme, oh, it's cheap, because for the most part, the amount that you'll be paid after representing someone pro bono is usually like 30K. It's not a lot of money, but sometimes it goes towards your CPD. And it is also just good to do it out of altruism. You've earned money in other cases. Chukua hii ufanye tu hiyo story iishe, okay? So pro bono services are offered in capital cases, as I said. You know by now what capital cases are, and cases of children in conflict with the law. And it happens a lot in the magistrate courts. Of course, it will happen in the high court because high court has jurisdiction, original jurisdiction. So at any point, if it's in the high court, then it will happen. So what you do, the court admin will call you, you'll sign a form, you'll give your practicing number, you will give your practicing certificate, a photocopy, of course, and then you will fill that form, and then you will represent this person to the end of the litigation, okay? Then when you're done, now you can be called to collect your fee at some point, okay? So who else provides this? I want you to remember Muhuri, that is a Muslim association. Kituo cha Sheria. Kituo cha Sheria is where we have these advocates. They are always willing to come on board as amicus curiae and for pro bono reasons. And then FIDA does the same. CLEAR is Christians Legal Network. Of course, we have these organizations that are really committed to ensuring that justice happens within the corridors of the law. And then the Law Society of Kenya. You remember we talked about the Law Society of Kenya? Hapo kwa pro bono, LSK will be just on the front line saying, you know what? If you want, like the time Aoko was detained for the first time, Aoko, the what do I call this girl? Aoko, you know Aoko. The first time, President Faith Moni said, you know what? I will bring Aoko, dead or alive, present her to us, bring her to court. We will offer representation, okay? So that is basically pro bono. And you see the case of R versus Karisa Chengo, you can use this in your criminal case. It is a criminal case. And Karisa Chengo really covers a lot of things. It also covers jurisdiction, okay? So this person was not accorded representation in their case, okay? So it was inconsistent with Section 36 of the Legal Aid Act and, of course, Article 52H of the Constitution and Article 49, okay? And then now, the lawyer who said, mimi, hiyo pesa yenyu ni kidogo, mimi sifanyi, alikuwa anaitwa Karisa Chuchubaya. Do not confuse it with Karisa Chengo, okay? But it's Karisa. Karisa was denied legal representation. Karisa Chuchu alisema, hiyo pesa ni kidogo. So what did Justice Philip Waki do? Punished the advocate, okay? He said those are rubbish cases. I'm not even coming for that trial. Kaini na hiyo trial yenyu. Mimi, I'm out here looking for good money and then you're calling me for rubbish cases. So Justice Philip Waki punished that Karisa Chuchubaya because of neglecting a proper brief, because that was a professional misconduct, okay? And of course, just like that, we are done with the proper briefs, proper briefs. And let's just go to the next presentation. I've realized when I open them fast it's easier. It's easier for me to share without being restricted when I open them fast. So let's look at professional undertakings. And professional undertakings, I hope itakujenga to the extent that I opened professional undertakings. I hope itakujenga to the yeah, here it is, to the extent that itakusaidia pia hata kwa conveyancing, because sometimes they cut across. Okay, so what is a PU? What is an undertaking? Of course, this is an equivocal declaration of intention addressed to someone who places reliance on it. Okay, who is this person who is making the unequivocal declaration? This is an advocate. Okay, this is an advocate, and if it is not the advocate, sometimes it is a member of your staff. And I want you to be very careful here. Okay, your secretary, your clerk can decide to offer such an undertaking, and it will bind you. It will bind you. Okay. Sometimes it is also a promise to do or refrain from doing something. Okay. The purchaser's advocate will say this: please give us the original title and the original KYCs so that we can go and register a transfer. Okay. And then after registering the transfer, then the full the balance price will be paid to you. Okay, there can be such an arrangement. It exists in conveyancing. Sasa wewe umeandika kwa undertaking yenu, mumeelewa, muko tu na hiyo agreement. Okay, because undertaking is done by the person who has the money. The person giving the money is the one who does the undertaking. Alafu wewe unaenda sasa unaanza kufanya mambo yako na hiyo title. Unaenda unafanya mambo yako. Then you've gone beyond the limits of the professional undertaking. It is professional misconduct, and of course there are consequences. And undertakings, umenotice huwa zinakuja mahali. We just want to make this path smooth for you. We want to make this path smooth for you. Vendo anataka kununua land but hana pesa. So banki inaambia purchaser, wewe purchaser wa hiyo sorry, si vendor anataka kununua land. I just confused you in a way. The purchaser wants to buy the land, but they don't have money. So the bank tells the vendor, you know what, give us the documents. Okay, give us the documents to register a charge. Alafu after hiyo, we release the money to you, utakuwa umeuza your land. So I hope up to there with those two examples you understand, and I know Sini has given you enough material for professional undertakings za kukupeleka wapi, za kukupeleka mbele. So topic 9 is PU, professional undertakings. You have to honor a professional undertaking. It has to be performed, released, or excused. You cannot remove yourself and say, you know what? Me, even this thing, I did not sign anything. So now I'm not going to be held liable. It is my secretary who did it. Happen. To fail to honor a professional undertaking is a professional misconduct. Okay. So we've said it's topic 9. And what does it involve? You make a personal promise. Okay. And this personal promise is legal. It is legal. It's something you're doing under the confines of law. And then it is a professional obligation. And what is it trying to do? It is supposed to smoothen the process of transaction. So anytime you offer this PU and say, we promise to do this, we promise to do this, then you know that you cannot go back on your promise. You cannot go back on your unequivocal declaration which someone placed reliance on. Okay, so what are you supposed to do under professional undertaking? Make sure you have the consent of your client. Okay, make sure client amekuambia fanya hivi. See that you decide to wake up in the morning, stero, you're going to issue a PU somewhere. Hapana. Make sure that everything is in tandem with the client. It should be in writing. It should be in writing. Okay, it should be in writing, and you must be clear. It should not be ambiguous. Okay, and when the advocate is not willing to take personal responsibility, let there be a clause. Let there be a clause that says, I am not going to take personal responsibility in the event of breach of Define the scope of the professional undertaking that you're giving. Okay? And then exercise diligence. Just make sure hii deal yote ni safi. Do not go do deals behind the scenes and then you come and say, it happened, it was a professional undertaking, okay? So we've said it helps to smoothen transactions. It also fosters public confidence. Let me tell you something. Kuitisha mtu title deed akupatie. It's not that title deed. Title deed is a very old name. Certificate of title. Pardon me. Kauzeka naingia. Certificate of title mtu akupatie hivi si rahisi, okay? Hata certificate of lease mtu akupatie hivi si rahisi. But ukisikia ni lawyer, it's the lawyer that wants, people give it, okay? So to foster public confidence in the judiciary, in enforceability, in the legal sphere, professional undertakings, when done well, they do that, okay? They have that effect, all right? So if you're asked about the rationale, number one, it will help to smoothen a transaction. Ka transaction akata tusumbua. Tunataka kufanya mambo yetu. Tunataka kufanya valuation. Tunataka kulipa stamp duty alafu tuende to register transfer. So wewe, hebu tusaidie na hizo documents tuende to register transfer. Alafu tukutolee hido. Hido, actually, tunaiweka kwa advocates account. Tulishaweka deposit 10% kwa advocates account. So ingine pia tutaiweka. The moment everything is okay, the registrar has registered this transfer, then all the money will be released to you, okay? So such things. What else does it do? It protects interests of the parties involved, okay? In case kuna kakitu kataenda wrong, then there's something you can use in the court and say, they gave me a PU. They gave me a professional undertaking saying nothing will go wrong, okay? And what is the case that we look at? It is Equip Agencies versus Credit Bank. These Equip Agencies told Credit Banks, able sell for us this real estate, this facility of ours. And Credit Bank told them, we will fetch you 17% interest. They gave a PU. Then they went and started fetching 1%, okay? They promised 17%. Well, may promise. You're giving an equivocal declaration that you're going to honor a particular obligation. Then someone is placing reliance on it. So you tell them 17%, you come and bring them 1%. Okay, you see how these things can go, okay? I hope that by now you are good. We are good with that. And how do we enforce undertakings? Let's look at how to enforce. Sasa utaendaje kusema Equip Agency, well, as the advocate of Equip Agency, utaendaje kusema Credit Bank waliwadanganya? Of course, you look for something like personal responsibility, okay? The bank can be sued, is capable of being sued, okay? Because it's a corporate entity. And then personal responsibility also applies to people in a sole proprietorship, okay? People in a partnership, you can sue them. And you can also just sue an individual like sole proprietorship. And there's this issue of Ambrose Diracher. This person was given an undertaking alafu akaanza kusema
wait a minute. Nakwambia saa zingine this is what I do. And then I chill, then I come back.
Kyoko, I'm waiting. I'm waiting, Kyoko, for you to chill and then you come back. Do you want to come back now? And why are you speaking like someone I know? Anyway, I hope you're good, Lillian. I hope I haven't scared you. So this Ambrose told Diamond Star, gave an undertaking and said, vitu zitaenda hivi. Then baadaye akasema, no, that wasn't an undertaking. That wasn't an undertaking. Iyo ilikuwa tu like something we said out of. We were just talking. It wasn't, but there was a letter showing that he had placed conditions. If this doesn't work, then this will work. If this doesn't happen, then this will happen, okay? So how do you approach the court? Of course, that one is through originating someone in the High Court. What else do we need to see under professional undertaking? Of course, there's the issue of the advocates disciplinary tribunal, okay? You will be reported to the Advocates Complaint Commission, and then you will face the Advocates Disciplinary Tribunal. And also, have you had a case? For the case laws, we will just send those for you. We'll send those for you. All of these notes, you will look at all those case laws. I think one that I've mentioned, the one for Equip Agencies versus Credit Bank, that should be enough. But if you can remember also Ambrose Rachel, that should be enough. And I want you to remember that if your employees give a professional undertaking and something goes wrong, then you are liable. Okay? Your employees, whether they are advocates or not, you will be held liable. Okay? And then undertakings by a partner. How do you do that? For partners, like general partnership, one partner acts as the agent of the other. Okay? So if one of the partners gives an undertaking, then it binds all the partners. Okay? It binds all the partners. And then if a new partner is coming in, then this partner is not liable for an undertaking made before they became partner. But the one that has left, an undertaking made when they were partner, my friend, you will be called and told, you know what? Ebu kuja, you are liable. Sawa sawa. So I think it's time to look at the next topic. I am really trying not to run, but at the same time, trying to ensure that you just get what you need. So we'll go to conflict of interest. Tuko karibu kumaliza. My guys, we are doing well, eh? If this gives you any solace, tuko karibu tunaendelea vizuri. What do I want to present? I want to share conflict of interest. It's a window. Conflict of interest, okay? Let's do this. So, what is conflict of interest? I will tell you in simple terms. If one day you find that your private, personal interest and the interest of someone else or the interest of the public, interest yako wewe kama Njeri na interest yangu mimi Magaa ama interest ya someone in the public, if they are clashing, then there's a conflict of interest. Of course, you know that you owe a fiduciary duty to your client, okay? You owe a fiduciary duty to your client, and you owe a duty to the public. So anytime that you feel like interest yako as Njeri, as John, as Akoth, as Kadima, no matter where you come from, inapigana na ile duty yako yenye unafaa upeleke kwa public, then already there is a conflict of interest. That's the best way for me to describe it. It is incompatibility between one's private interests and one's public or fiduciary duty, okay? And so PEC 6, mute. So PEC 6 talks about conflict of interest. And I will not even define it. I will remind you of George Luchiri Wajakoya going to tell Obado, I'll be your lawyer. And then when he was refused the job, when he wasn't retained by Wajakoya, what did he do? Rushed to the victim's family, rushed to the complainant's family, Mamaya, the late Sharon, and said, you know what? I am here. In fact, najua siri zingine za huyo mtu. They've told me everything when they were being held in Gigiri at the cell. Okay? And remember, your Advocates Act, Section 2, defines a client as someone who is about to retain an advocate, among others. Of course, it is a long description. It is someone who retains an advocate, someone who pays, and the last one is someone who's about to retain an advocate. What is the scope of this? The scope of this is what Zakaria Okoth Obado and George Luchiri Wajakoya went through. Wajakoya is the former presidential candidate, okay? Anaenda anapatiwa siri pale Gigiri and then running to the other side and saying, wameninyima job, now I'm going to win this case. That is SOPEC 6. You see Wajakoya, you see Zakaria Okoth Obado. I want you to see SOPEC 6 and I want you to see conflict of interest. And I want you to see Advocates Act Section 2, defining a client as someone who is about to retain an advocate, okay? I hope that works for you. And what you should do first before you say what you should do, let's look at how SOPEC 6 will define this conflict of interest. Adverse interest, okay? So this Wajakoya definitely wanted money. They wanted, sijapata kwa kina nani Obado, now I'm going to get from akina the family of Sharon, okay? And these are also factors limiting effective representation. Because what if Obado told me, I did it, okay? What if Obado told me that? Then it means me as Wajakoya, I'm going to limit effective representation because I'm not going to do due diligence. I'm not going to bring evidence suggesting that he did it. I already have it. And how do I have it? I have it from him self-incriminating, him telling me. And he has the right to not self-incriminate, okay? So there's also risk of unauthorized disclosure of information, and there's loss of independence by advocates. Under your duty as an advocate, you're supposed to be independent under the Bangalore principles. We talked about impartiality, we talked about integrity, we talked about independence, okay? We are looking at such things. So the moment there's a conflict of interest, already things have just gone south. You can tell by now looking at Wajakoya's case, or Okoth Obado versus Wajakoya's case, okay? And there was that also in King Ulen Mills, and another versus Kaplan and Staton. These advocates wrote documents, the loan agreement, the legal charge, and other documents for all the three parties, okay? For all the three parties, because there was the chargor, there was the chargee, and there was the grantor, okay? This person akawandikia wote the documents. So the moment these people got to a point where they had a dispute, now he still wants to represent one party. And this other party went to court and said, he knows a lot. This person knows a lot. Hapana, hawezi represent our watu, which means that there was a conflict of interest. Sawa. And so what are the rules that will govern your SOPEC 6? SOPEC 6, conflict of interest, Wajakoya, King Ulen. I want you to remember that. Section 2, Advocates Act. What are the rules? Of course, there has to be full and frank disclosure of conflict. Just say, I am conflicted. Hii deal ilikuwa inaenda kukuwa poa, lakini I am conflicted, okay? And then never act against your client. They're called Stratton, Kaplan and Stratton. These people, by the way, are they still in Karen? These are Kenyan advocates. They used to be in Karen, and they are very high-end firm, okay? What the advocate was trying to do, it was like going to act against a client they have acted for before, okay? So never act against a client you have acted for in a similar or related matter, okay? And if you see that there's conflict of interest, of course, we say that here, just make full and frank disclosure of conflict and say, I cannot do this. And so for this reason, I'm going to just step aside and let someone else handle this, okay? Because if you do not, and you continue acting, and something happens, then it amounts to a professional misconduct. In fact, if you don't disclose, you have to disclose. You disclose, and sometimes when you disclose, the court will okay it. The court will okay it and say, I think it's okay. It's okay. In this situation, there is no problem. And there's that case for Rakusen versus Ellis, okay? Rakusen versus Ellis, they were different transactions. And in fact, one of them was going to be an arbitration process. So the court said, no, we don't see any problem. It is okay. Rakusen versus Ellis, there's the Rakusen versus Ellis case, okay? So you're supposed to disclose ndio court wakae. For judicial officers, for judges, inakuanga, for presiding officers, judicial officers and judges, inakwanga, what happens? You disclose to the court and say, I cannot be a judge in this matter because I am conflicted. There's conflict of interest. And then, like in the Gladys Cholet case, the court will say, you know what? There's a duty to sit. There are some elements that will prohibit the court from allowing the judge to recuse themselves, you know, the recusal process. They'll say, there is a duty to sit. So in this case, this person will sit. But the fact that you've disclosed this conflict of interest will allow the court, through its discretion, to either allow you to sit or disqualify you. Sawa. I hope we get up to there, and we are good. The rest is just case laws and maybe minor legal framework that you will look at. And this last one, of course, is the recusal that I was talking about. If you are a judge, alafu it is quotas coming to court, and you are a child of those quotas, mmekuwa mkiishi mahali you're living somewhere, like the Mitubel case or the Malindi cases that have been there, the North Coast cases ya quotas. Na wao liteseka, mulikuwa mnashindwa, mmefukuzwa na kaburu mkiwa wadogo, and you're a judge on that table. And the squatters are now coming to court. You want to represent that case? No. You have to, number one, declare that conflict of interest, and then you seek to recuse yourself, okay? Recusal. You say, hapana, mimi sitaweza kukaa kwa hii meza kwa sababu kuna conflict of interest. And then the court might say, for the High Court to be properly constituted, for the Supreme Court to be properly constituted, we need for Supreme Court, we need 5, and we have 4. And at this point, we need that other person to come. Akuja kaa hapa, okay? And there is no way. And so we are going to trust that this person's duty to the court will override his personal interest, because this is an office. This is a presiding officer, okay? This is a presiding officer. This is a judicial officer. So we're expecting this person to abide by chapter 6 of the Constitution, and we are trusting them. No matter how big that conflict of interest is, we want to trust that because of their qualification, because of their experience, they are going to exercise an impartial and a neutral judgment, okay? So that is conflict of interest, topic 6. I don't think there is much more to say after that. I'm just going to present the next. Which is this is limits of an advocate's duties. Okay, limits of an advocate's duties. Let me just present it. It's a very quick one. I hope we get to the test papers. I've seen interesting questions for the test papers, and we will. And the one for last year, particularly, I had a few things to say about it. But let's finish this, and then we go to the past papers, and then we see what we can get before you guys get to saturation, okay? So far, this space is good, okay? This is God's space. So what are the limits of advocates' duties and rights and privileges and obligations? Sawa. You have a duty to your client. You have rights, you as an advocate. I do not have rights, okay? You have the right to be compensated, of course, to be remunerated, to be placed on a retainer, okay? And then you have the right to lien when you've not been paid, okay? You have the right to represent, and then you sue for your fees later. And then you have the privileges. One of your privileges in court is if whatever has been revealed to you in confidentiality by your client is furthering an illegality under the Evidence Act, then what are you supposed to do? You're supposed to let your duty to court under Section 55 override your duty to the client, and the court will protect you, okay? Rondell versus Worthley, okay? So you're doing your duty to court. So there's that immunity, okay? Then you also have obligations to the client. And I'm not going to repeat the duties of an advocate. We did a whole topic on that. So what are the limits to your duties? What are the limits to your rights? What are the limits to your privileges? And what are the limits to your obligation? Number one, what can be the limit to confidentiality and privilege? And I've just said it. Section 134 and 137, okay? Section 134 and 137. If you have information about the client, that is private communication, okay? Duty to the client, your confidentiality, but it is furthering an illegality. What do? You report to the court under Section 55 of the Advocates Act, okay? So hapo kuna limit, okay? Kuna some limits to your duties, okay? It is limited, but you are empowered. You're called an officer of the court under Section 55, and so it works well for you when all is said and done, okay? What are the limits to client's property? My friend, this one, Section 80 is betrayal of trust. Client has given you some money, like some retainer huwa unalipwa, so that we look at kinds of retainers. You're paid so that you're available on call. You're paid so that you finish a specific work at a specific period of time, okay? So this client's property this client's property, you must be able to hold it within the confines of law. Do not misuse it. Do not go withdrawing money from clients' accounts and using them for your own good, okay? So client's property is SOPEC 5, okay? It is SOPEC 5. And then we have advocates account rules. And here it treats you as a trustee of the client. Any money that you hold for the client is not your money. And actually, you should open an account for clients, Kando. You should not mix it with your separate account, okay? You're also allowed to hold on to a client's property until they pay you what they owe you. But you're not supposed to start selling it, misusing it, okay? So that is client's property. That is client's property. We've talked about money, how you're supposed to hold it. We've talked about things that you can hold in lien. Usitumie vibaya. Do not overdraw advocate's account. Umeamka tu hivi, you want to go some shopping and then you go to the advocate's account and you take the money, okay? You must think of consumers' rights, okay? So if a client has trusted you sometimes to buy them like something, like a property, do not go buy them some knockoffs over there and then you harm them in the process. So that is Article 46 of the Constitution of Kenya, okay? It is Article 46, of course, of the Constitution of Kenya. How else are your rights as an advocate limited, okay? You are supposed to advertise. You're supposed to advertise your services as an advocate, but they are limited in the sense that you're not supposed to be touting. What is touting? You're going to look for people. And usually there's a certain court where there was a fight. The people coming to the criminal court were coming from the buses. From the buses, wanaletwa from different police stations and different remand, and when they were coming out, the advocates were running towards getting the clients. I will not reveal because it's something that was kidogo made private to be handled internally. So what they started doing is they started calling each other names. Then watu wakashikana mashati. So these people have they've been they have to answer to professional misconduct under touting and just misbehaving in public, the names they called each other, the way kata shatia each other, okay? So there's advertising, and we look at the marketing rules, and the case law is Judge Okay Mwanza. Next, I think it's the next or second next topic. And then you're not supposed to undercut. You're not supposed to undercut. We kuja nitakufanyia 2K ndio hii story ishe. Way you're not supposed. There are rules. Yeah, there's the advocate's remuneration order. There's a way of you charging, and then don't undercut so that you take clients away from your peers, okay? Then do not share profits, okay? And then do not sign like documents for unqualified persons, or you give them documents to act like you. Recently, just in another court of law, because I tell you people, these things come to light. Some advocate, some guy, not advocate, he's been coming to court, and he's a sharp guy. Kumbe, another person has been feeding him details, and he goes there to court and wins cases, and so clients are following him. We know this is a reputable lawyer. So your rights, your duties, your obligations as an advocate, ziko limited. And one of them ni, don't give documents to unqualified persons. Don't cooperate with unqualified persons to act when they do not have the capacity to act, when they're not supposed to sign documents. And then there are also issues on limitations on witness preparation. Do not coach witnesses. Wewe ukiulizwa hivi useme ABC, okay? Then in demand letters, of course, do not ask for your compensation or your money there. This 1, 2, 3 things, okay? This 1, 2, 3 things that you see all over the place. If they're supposed to be limits, of course, those limits are limits to your duties, okay? Then they may sometimes limit your rights. They can limit your privileges, and they can also limit your obligations, okay? So do not coach witnesses or be we danganya, usiseme nini, and let's also look at thoughts of an advocate. So what are the thoughts of an advocate? They are really based on negligence or malpractice, okay? They are based on negligence or malpractice. And SOPEC 3. SOPEC 3 tells you where we make sure you exercise competence and diligence in client care, okay? Do not just under prepare. You're just writing the last minute today morning, doingie kotini is when you're writing your submission, okay? Make sure you really prepare so that the client does not feel like they were disenfranchised, like they lost the case because you did not give a competent representation to the advocate, okay? So that could be one of them. It could be, you could be sued for negligence. And then, of course, you've seen the issue of professional indemnity cover, where if something happens because of you as an advocate, okay, and you are professionally liable because you made an error or an omission, or you just for some reasons is responsible for professional misconduct on the part of the client, then you are able to indemnify the client as an advocate. And every year, if you have a law firm, you have to take out a professional indemnity cover every year. And what are these risks that can happen for you to be required to take out a professional indemnity cover? Breach of confidentiality. Oh, umepewa masiri huko, umekimbia kusema pale mbele, okay? It could be also employee misconduct, something done by your employee against the client that really causes, ampoteza documents fulani, okay? Given the wrong people is something that maybe like some compensation that came out of the litigation, given it to the wrong people, so pesa imepotea na imeenda hivi, okay? Then it can be a breach of professional duty. You're not even attending court to take care of your client, or you're lying to the client, misleading the client, something like that. It could be defamation. Unaharibia your client the name. Lots of documents we've talked about. Omission, things you fail to do. You remember, if there's omission, there's commission. Commission is things you do, but omission is things that you fail to do. So possible professional risks are those, okay? You can breach confidentiality. You can just be caught in employee misconduct, breach of professional duty, defamation, loss of documents, omission consequences, and then they can be dishonest. And you can be dishonest, and then now this, when you're being dishonest, then this is a cause for disciplinary hearing. In this sphere, hizi vitu zote, you will find yourself being a subject of a disciplinary hearing, because there is the remedy is usually to report to the Advocates Complaint Commission, okay? And if it is not something they can solve at that level, like dismiss or solve it or direct it to mediation, then they'll refer it to the Advocates Disciplinary Tribunal, okay? Sawa. So advocates and marketing rules, this is not the whole of it, but I want you to know that there's the advocate and marketing rules, which shows that to what extent we are supposed to advertise, okay? Businesses. To what extent are we supposed to advertise our business? I will tell you even before we get to that topic, that you're supposed to put a signage hapo nje, okay? And that signage, it has the size, recommended size, and you kupita, okay? You're not supposed to go on radio. You're not supposed to go on TV. You're not supposed to be on YouTube marketing your jobs out there. And for print, there is a size for how the print should toshana, okay? And this happened when that George Okeo once went to court and said, other countries, other jurisdictions are advertising their work. And Article 46 of the Constitution, Consumer Protection, involves peer explaining, making the consumers aware of our services. And we are the legal profession. We are supposed to give people access to justice under Article 48. And we are not telling people where to come and access justice. Is this even fair? So there was a back and forth, of course, in court, but eventually the court said, you know what, we are going to allow advocates to advertise their services, but what we are going to do, we are going to really limit this. You cannot go on radio and say, hey, come to Emaga advocates and Nini and come and we will win this case for you. We will win early in the morning. We will win before the you know the gavel of the judge goes down. No, you cannot do that. But America, I've seen America, they do wonderful advertisements. Other jurisdictions do it, okay? So we will look at marketing rules in depth, but I think what remains, it will just look at it to see this, the sizes, the measurements that you should have when advertising for print and when putting the signage on your door, okay? Sawa sawa. So why are your duties, rights, privileges, and obligations limited? Why are they limited sometimes, okay? They are limited because it is,
Mwalimu,
yes?
sorry to interrupt, but could you kindly enlarge your screen? It's really tiny.
It's tiny.
Yeah, I'm struggling to follow.
Okay. What would it work if I increase I zoomed it like this? Like this?
Yes, yes,
Ah,
yes.
I hope you've
Thank
not
you.
suffered. I hope you've not strained, Sana, for you to speak out, Usikue umeumia sana, okay? So why are these rights limited? Because you know that if these clients are not protected, it's for the protection of the client. If they're not protected, then we will have things like abuse of powers. Because for something like betrayal of trust, the client has trusted you with their money, and you decide to put it in your own account and not the client's account, and then you are supposed to be the trustee with this money, but you take it and go shopping. And if there's no law that prevents you from doing that, are we really protecting the client? Even under Article 46 of the Constitution, okay? And Section 46 is about some agreements that advocates enter into with clients, and they say able to agree heavy invalid, they're called invalid agreements, okay? So these limitations have to be there because they have to be checks. There have to be checks. There has to be someone that checks you, either a law or say a commission or a society that checks you, so that we are able to conduct ourselves in a professional manner. I hope that you know that the locus classicus test for negligence is the Bolam test. Okay, this is for doctors. So this Bolam guy appeared for some experiment. Okay, and in the experiment it ended up being bad, like they lost a leg or something. And so when they sued the hospital, the doctor said, in our submission, we really exercised care and professionalism. We did the best we could, okay? And so it was held in this case that a professional person will not be guilty of negligence if they can show that they acted, they did everything. That money for the client, I placed it in the right place. I represented the client the right way. I attended and communicated to the client to attend courts on the right days. The professional undertakings that I gave, I adhered to all of them. All of them sailed through. The transactions were smooth, all right? My duty to inform the opposing side of something, I communicated to them. I served them. I gave them an affidavit of service, all right? If I was to write a response to them, maybe a defense, I did that. So if you did everything in your capacity as an advocate, and then something occurred that they're likening to negligence, then you will not be guilty of negligence, okay? So this is the Bolam test, in case you've not heard about that case before. If you've not heard about that case before, that is the Bolam test. And of course, when you talk of negligence, you must remember Donohue versus Stevenson. This is first year undergraduate. Mimi, I'm not going to repeat it to you. It is even on Wikipedia. I saw it on Wikipedia the other day and I said, kumbe Donohue versus Stevenson imefika hapa. Okay? So we are going to look at conduct of advocate. I think tunamaliza. Mebaki kidogo. Yes, I am very happy kwa sababu mebaki kidogo. I hope we get to the test papers. I'm excited. I hope you also excited with me to get there and in good time so that tomorrow uamke ukiwa fresh as a daisy. So let's share the conduct of advocates and lawyers in other societies. And if you've noticed in professional ethics by now, some of these topics really repeat themselves. They repeat themselves. But so far, we've been handling advocates. And advocates is, I'll give an example with you when you start practicing. But there are people we've not looked at who are also advocates and lawyers in the society. They just belong in other spaces, okay? Sometimes they work together with day-to-day advocates, but sometimes they do not, okay? So are judges judicial officers, okay? Are they? And Article 161 define judiciary, okay? It will define the judges, superior courts, magistrate, judicial officers, and stuff, okay? So Article 61 has that for you. But Article 260, if you look at it, a judicial officer is a registrar, a deputy registrar, magistrate, kadi, or the presiding officer of a court, established under Article 169. So the presiding officer of a tribunal. Sawa sawa. Okay. Senior text. Noted. So I want you to know that judges are not judicial officers. They are presiding officers, okay? Because judges begin from High Court, the Superior Court. Just know today, judges are not judicial officers. If you want judicial officers, unaenda uko chini, okay? Ukiteremka, sawa sawa. So this is pretty much defining those people and placing them in the places where they should be. So you'll see like the articles will give you the jurisdiction na kila kitu, okay? To give you the jurisdiction, there's nothing much there for you to see. 163 by now, you can sing article 162 to 169 bila mtu kukuuliza, sawa sawa. And I also want you to know that when they talk about the independence of the judiciary, of course, because we are talking about lawyers in other spheres of the society, independence, one of the reasons why it is called an independent commission is because it raises its own funds, okay? It raises its own money and it gets its money from fines, surrender. Of course, there's cash bail and there's civil matters of the court going on, sawa sawa. And then for Bangalore principles, I told you to write independence. All lawyers, all advocates have to be independent. And what else? They have to be impartial and they have to exercise integrity, propriety, and equality and competence. And did I mention impartiality? So the principles that the judiciary are supposed to abide by are just the same. They are what chapter 6 is about, and then they're just the same as the Bangalore principles. And of course, what are they looking at? Some of the things they're looking at is the chapter 4, like Bill of Rights, okay? And this one, if there is proper administration of justice, then the Bill of Rights will not have been violated, infringed, or denied, okay? And if we are even going to expand it, we're going to talk about Article 22 and 23, where you have the locus standi and you have orders that the court can make, okay? I just made that so simple for you. There's, of course, the Judicial Service Commission Code of Conduct. They have their legal framework. There's the Judicial Service Act. There's the Judicial Service Commission Code of Conduct 2020. And this one came because of the Corona. If you see Code of Conduct 2020, it became because of Corona. It came because of Corona. And it was Emeritus Justice Maraga who was saying now, we need to have online court processes, okay? And these are the rules of the court process. This and this will happen as we proceed with our online court processes. And of course, there's international principles. And that is, for the most part, what you need to know about judiciary. The rest you already know, and you've gone through the other one in class. Let's look at the Office of the Attorney General. And the Office of the Attorney General is, of course, under the Office of the Attorney General Act, okay? It is governed by the Constitution, SOPEX, and Public Officers Ethics Act. Let me make also this one a bit bigger, even for myself. Okay. And who is a state officer and who is a public officer? Okay. You will find that there can be a very thin line. Okay. So public officer is any state officer or any person. Public officer is any state officer. Okay. Or any other person than a state officer who holds public office. So wachaneni na hiyo. Hiyo it means understands how I write it. So public office anyway is an office in the national government, a county government, or a public service. Sawa sawa. So if someone is to be called a public officer, is someone asking something? If someone is to be called a public officer, it's because they hold a public office. Okay, I want you to remember that they hold a public office, so they are called a public officer. And for state officers, of course, we have the president, deputy president. Tuko na hawa watu wote mnaona hapo. We have all these people under chapter 8, chapter 9, and chapter 15 of the Constitution. Okay, who is a state council? Who is a state council? Unasikianga state council. That is a public officer. Okay, so if you work for the government utapata unaitwa state council. Kama kwa hiyo ofisi ya attorney general utapata unaitwa state council. And what are the things that you're supposed to do? Just like the duties of an advocate and a lawyer, you're supposed to avoid conflict of interest, avoid enriching yourself in this government office. Do not discriminate on the people, dress code, behave in a manner that promotes Article 10. Article 10, we said it's very rich, it's patriotism, it's culture, it's equality, okay? And then, of course, you behave yourself under chapter 6 of the Constitution, which is leadership and integrity, okay? And what else? There's this, do not use office for harambes, be neutral. Wachana na mambo ya politics, unafuatana na watu wa siasa. You're going over there to endorse someone in an office. Avoid nepotism. Do not hire people from your family in the office. Do not evade taxes. Do not abuse powers by engaging in sexual harassment. Wewe sasa ndio unataka kubaltaza the entire office, okay? So the office of the Attorney General is governed by the Attorney General Act. Of course, there's the SOPEC, there's LSK, there's the Constitution itself, there's the Public Officers Ethics Act, okay? Then we also have the Office of the DPP, okay? We have the Office of the DPP, and we have the Code of Conduct that governs it. It's called the Code of Conduct of the Office of the DPP. We have the DPP Act, okay? If we want to look at some of see that the DPP is involved in criminal cases, okay? These are prosecutors. These are prosecutors and they follow the Constitution, they follow the criminal code, and they follow of course, the penal code, and they also follow the DPP Act. So what is their responsibility? Their responsibility is to prosecute cases. They prosecute cases, okay? The investigation officer or the arresting officer, then the investigation officer, the moment they finish, they hand over to the DPP, and now the DPP is the one who opens charges. I think you know that by now. You know that by hiyo tunarudia because it is important that we mention it. It could add to the 1 mark that you need tomorrow. Maybe you just need that 1 mark to make it a pass, okay? And so the DPP has powers to prosecute cases, and they also appoint public prosecutors, okay? If you go to any criminal court, you will find prosecutors. The composition is usually either a magistrate and a prosecutor, or a judge and a prosecutor. Sawa sawa, and of course, kutakuwa na the defense. Sawa sawa. So as we are continuing, we look at let's look at remuneration. Let's look at remuneration. We will not go slide by slide. We will mention what is important to Malize. We just call it a day after we finish. So let's look at remuneration. Okay. I hope you can see the presentation, okay? So if you look at your Advocates Act from section 44 to section 52, okay? It speaks to remuneration. And you must know that it is the Chief Justice who stipulates what remuneration advocates should be paid, okay? And I told you there is the advocates remuneration order. I want you to write there. I want you to write there. Advocates remuneration order. So the Chief Justice will stipulate what the remuneration will be. And then under section 45, section 45 talks about agreements that can be made in respect to remuneration, because there are many. Tunaweza agree nitalipwa hivi ama nitalipwa hivi ingine, okay? And then now section 46 talks about agreements about remuneration that are prohibited. Wacha ninunue that thing from your hand so that we do this, na wewe nilipe hivi, na wewe nilipe hivi. All those things that can lead to professional misconduct by an advocate is section 46, and those are invalid agreements. And then now section 47 allows an advocate to exercise the right of lien. Mimi nimeshikilia property na huyo anilipi. So now let me go to court so that court can say, you know what, you're supposed to pay this. You're supposed to pay this person, okay? And I want you to remember the case of Nani P. Machira versus James Abok that we mentioned in the previous slides, okay, or PowerPoints, okay? So how are advocates remunerated? How are they paid? How do the retainer agreements work? It could be hourly, where some people, when you hire them, akina Cliff Ombeta, from what I hear, do not quote me. Mimi pia ni rumamonga too. I am just a rumamonga. From what I hear, they say, hey, I'll charge you per hour. Okay. But I know Kaplan and Staton, they do that. Okay. And then it could be a flat fee. It could be a contingency fee, sometimes dependent on a win, although this has restrictions, okay? And sometimes it could be a percentage fee of a transaction, okay? Now, you lawyers, you're told, usichukue pesa kidogo, you're prohibited from undercutting. Do not charge below ndio upate pesa haraka haraka, okay? It should not make it make sense. You've gone to school for so many years. Alafu upatiwe 500 na mtu and then you get into court and defend them. No, your fee is supposed to be reasonable, okay? So do not just take money because unataka kushinda wenzako, you take money. So what factors do determine the reasonableness of legal fees? The time and the labor required. Some people put lawyers, advocates on retainers forever. You're my lawyer on standby. I need you for this. You're the one I've given power of attorney. I need you for this. You're the one to do this. I need you to ensure my children school fees yao imelipwa kila kitu. It is you. So it could be forever, okay? And then also what other clients will do, they will pay you legal fees so that you don't act for other people. You just act for them, okay? So if they see that you will accept employment from other people, they will pay you not to work for other people, okay? And then sometimes it's just normal fee. This is the legal fee for this and this. You're supposed to pay this. So let's just work like that. I'll pay you after this to Malizani. Then there's also the results obtained, which I've told you, this one you act on very carefully, okay? It is usually dependent on a win, but it has some limitations, okay? So sometimes if a lawyer, an advocate, and a client have had a long-standing relationship, then the legal fee might also be dependent on that. Wewe wanakulipa tu kila mwezi, so we relax tu, mshahara wako itakuja, but kimbia kotini, you just make sure that you've done this and this, and you've taken care of issue A, issue B, issue C. So the slides that I'm opening hizi ambazo nafungua, they're just what I was explaining. And what else do we need to see here before we go to the next topic? Yeah, we have case laws. Zitawapeleka vizuri. These case laws. Look at only one today. Usiangalie vitu. Don't go cramming 10 case laws, okay? Look at one and then add to those case laws that you already know. So let's look at retainers. Let's look at retainers. Okay. So what are retainers? What are retainers? We look at remuneration, mshahara yako ambayo unapatiwa. And it almost sounds like it's the same thing. Okay? And sometimes it's the same thing. Okay? So I'm going to look at a very simple description of retainer. I'll say lump sum fee paid by the client to engage a lawyer at the outset of a matter, also known as an engagement fee. Okay. Of course, there are several descriptions of retainers, but we are not going to cram 10 today. Okay. I want you to know that remuneration is an advocate being paid according to how the Chief Justice has set the rules. And the rules are in the advocate's remuneration order. And this payment will be dependent on the time of engagement, okay? The period, the specific duty that they're supposed to do, the duration of their relationship, maybe they've known each other for long, okay? So this remuneration, the Chief Justice has already set it under the Advocates Remuneration Order in the Advocates Act. So what happens in a retainer now is now this this client deciding to pay you, okay? This client deciding to pay you according to the work that you are performing or will perform in future or have been performing, okay? So this is the money that you're given ya kukwambia hebu we shika hii ndio utafanya kazi. But for the most part, it's usually called, people call it a booking fee. Okay? It is a booking fee. Hebu we shika hii pesa in case anything happens, okay? In case anything happens, wewe nitakuita. Okay? Ama shika hii kabla tuanze kazi. Bado you have not charged for the cost of services zenye umerenda, but amekuweka kwa hii retainer. Wewe kaa hapa, wewe ndio lawyer wangu, wewe ndio nakutaka. Okay, I'll call you. Take this. We have secured your services now. You're going to be the person that is going to represent us. And I'm over repeating myself because there are a lot of descriptions to retainer, and there are a lot of circumstances where retainers occur, okay, or retainers are paid. And just remember that retainers should conform to the advocate's remuneration order, okay? And retainers should not be invalid agreements, okay? A person to Section 46 of the Advocates Act, okay? So, this is a case law. I want us to look at the forms of retainers, okay? General retainers. This one, it secures the services of an advocate. There is no contentious business. Hakuna kesi kotini. But what it does, the client pays for a specific period. They are contemplating, mi nitakuhitaji, naona kama nitakuhitaji. Let me pay you this money, you're my person, okay? So it is a general retainer. So what they will do, either party can give a notice for termination and then they decide, tumemaliza because maybe whatever they were contemplating already happened. They've finished the representation, or whatever they were contemplating didn't happen at all. Some advocates are booked and we said they are even paid by the hourly fee, okay? So this person sees problem incoming and they call the advocate. They tell them, hey, I'm putting in your account the retainer so that if this happens, if they bring this and this case against me, mimi niko na wewe, okay? Then we have hybrid retainer. We have hybrid retainer. And this hybrid, the name speaks for itself, okay? So they will give you an engagement fee at the beginning of the work. They'll tell you chukua hii. And then after that, they've given you at the beginning. And then they say, as much as to make pay engagement fee, ukue lawyer wetu, tunataka pia kukupatia the money that what we think it might cost for you to perform your work, okay? So hybrid has engagement fee and retaining fee. And I hope that up to now, you're seeing the difference between remuneration and you're seeing the difference, you're seeing the difference between remuneration and retainer, because I do not want you to get confused. I do not want you to get confused at any point. A good retainer must conform to the advocate's remuneration order. There goes your tip. There goes your huge tip for the day. You must know that what comes first What comes first is the remuneration, and then after hiyo kuna kuja retainer. We'll come back to Lien. Let's look at marketing and advertising rules. We'll come back to Lien. Let's look at marketing and advertising rules. And I told you there was a guy called Jojo K. Omwansa, and this guy went to court and said, we are not advertising, we are lawyers. We have our Article 46 over there, consumer rights. We have the right on information, Article 35. We have SOPEC 34 and 35. And then we are not, no, by then there was no SOPEC 34. Let's first start with Article 46 so that we get there. Consumer information, and then kuna access to justice pale Article 48, the right to information. Na sisi ndio lawyers, and we are a profession that is honored. We are a profession, we are not a trade. And then we are not advertising. So now went to court and said, we want to have marketing and marketing rules for Kenya as well. Okay. Justice Majanja said, huyu kijana ako na pupa mingi, ametoka kufanya masters America, analeta hiyo ujuaji yake hapa. But later on, this guy was given audience, okay? This guy was given audience, and so they amended Section 32 of the Advocates Act, okay? They amended it, and they came up with, after amending Section 32, they came up with the advocate marketing rules, okay? And there was the rule 2 of the advocates practice rules, which was saying no advocate may advertise at all. Walikuwa wamekataa kabisa. Okay, rule 2. That was rule 2 before it was amended. It used to say hakuna advertisement of any form. So if people want you, maybe if they've seen you in court, they will follow you. And then the cab rank rule. The cab rank rule inakuanga, si huyo advocate amepata client, then the next one should do it, and then the next one, and then the next one. But George's argument was like, how do we know? How do we even know that these law firms exist if we do not even see these law firms? Okay? We do not see these law firms. There is no signage. These people are not allowed to advertise on print. They are not allowed to advertise on social media, okay? Which still it is not allowed for you to advertise on social media. There is no advert on radio. And Okeo had gone for the whole thing. He wanted for the advertisement, he wanted for the advertisement to be done everywhere, okay? So when the advocate marketing and advertising rules came, now 2014 came, the rules permitted advertising. Number 1, I said you're supposed to do your identity outside of the farm. Signage, unaweka tu hapo, unasema, ndio hilo farm yetu tuko hapo, okay? Kwa mlango pia, you can put your address, the hours of business, the language of business, okay? What are your academic qualifications? Sometimes you see something, let's say academic or professional, you see something there written, commissioner of votes, okay? You'll see hapo kwa mlango imeandikwa, okay? Then, any contribution that you have done to the preparation of any public legal article, any contribution that you've done, but this one you will not put on the door. This one you will put on that print that you are allowed to advertise on, okay? You are not supposed to advertise on TV. You're not supposed to advertise on radio. You're not supposed to do a billboard. You can only advertise in print and no more than 4 times a year. 4 times a year peke yake ndo unaweza enda ujitangaze pale ndio watu wajue wewe ni nani, okay? So they are saying that if we open the profession, okay, what they were arguing over here while coming up with the marketing rules, they were saying if we open the profession too much so that people can advertise left, right, and center, it is going to market it down. And I'm telling you an example. You saw that with the media industry, okay? You saw that with the media industry. When they started opening colleges in 12 floors in town, media just became a watered profession. Now anyone can become a journalist with your phone. You can get news and put it on TikTok. And that is what the law profession is restricting. In a way, it's a good thing. In a way, it's a bad thing. Okay? You can't really say in a nini sana, in a restrict sana, but also you can't say it's a bad thing. it's a good thing, because the moment this profession is opened to endless advertising, and you know the way Kenyans know how to take advantage. We are Kenyans. Kenya is our business. There will be a lot of advertising. The profession will be watered down. Kutakuwa na issues nyingi za undercutting. There will be touting. Okay, there'll be a lot of things that the law is trying to shield us from. So what advocates can advertise on print, they can advertise through website or a placard at the door. The size of the signage is usually 0.5 times 0.3 centimeters. Okay, this is kwa mlango. Okay, and then kwa print media 0.1 times 0.2. Look at this. You can just say 0.5 times 0.3 and 0.1 times 0.2. Yani tunafaa tukue tu vitu tudogo. Kama hiyo signage kwa mlango, inafaa tu ikuwe enough on both sides yenye someone coming approaching your law firm can see
We
and can see.
can't see your screen.
You
We
can
can't
see my
your
screen?
Yes, we cannot see your screen.
Oh, sorry about that. Let me just present. But you saw the previous slide, right? You saw the previous slide.
Actually, the whole what is it called?
Marketing and advertising.
Yes.
Yeah, we have not been able to see anything.
Oh, but did you grasp anything? Did you grasp the case of George Okenyo Omwanza versus Attorney General?
Yeah, we grasped the case.
Mm-hmm.
Mm-hmm.
Okay, if you grasp the case, then let me just go through it quickly. So Okenyo goes to court and says, oh, Article 46, which is consumer protection, okay? And then Article 48, access to justice, is being underutilized. And the funniest thing is this is within the legal profession. Why? Kenya, the rules of Kenya do not, Rule 2 of the advocates practice rules do not allow us to advertise. Okay, so how are we going to tell people about our business? And aren't we hurting the public because we are not giving the public the right to information, consumer information that they require, which means that we are denying them access to justice. Okay, so at first Justice Majanja says, apana, we are not entertaining this, but this judge does not give up. Okay, he keeps going. And eventually they amend section 32 of the Advocates Act. Okay, they amend it, and then other than that, they come up with the Advocates Marketing and Advertising Rules. Okay, they say you can advertise in print 4 times a year, not more. Okay, you can advertise on your door. Okay, you cannot advertise on radio. You cannot advertise on TV. And when you're advertising, you must say the year. You must say the year when you're admitted. You can put your address. You can put your hours of business. You can put the language you use, okay? Your academic profession. So you can advertise where? Print. You can advertise on your door, and you can advertise on your website. And also, if you do like legal or scholarly articles, okay? Or a legislative bill, any contribution that you've done, then you can put that, say, in the website or in the print. But we are telling you, do not go on billboard, do not go on TV, do not go on radio, do not go on social media to advertise. We are prohibiting this because if you allow you to advertise, this profession will not be the profession that it is. People are supposed to find your way to you if you're a good enough lawyer, okay? But because Omwanza has argued that, hey, you not allowing us to advertise is denying people access to justice. The issue of public interest, okay, Article 48. And then the issue of Article 46, consumer protection involves giving them information, okay? So if you allow us to advertise even a little bit, then people will come to us, okay? People will come to us. So that is what happened in a nutshell. That is all I've been trying to say. So if someone asks you, how did the advocate practice and marketing rules 2014, how did they come to be? Then you put George Okeo Omwansa or George Omwansa or Omwansa George versus the Law Society of Kenya and of course the AG, and that is how they formulated the Advocates Marketing and Advertising, not practice, Advocates Marketing and Advertising Rules of 2014, and they also amended Section 32 of the Advocates Act. It is as simple as that. Just know you're allowed print, you're allowed to advertise in your website, and you're allowed to advertise at your door. Don't go to radio. Don't go to social media. Don't go to TV. Don't do billboards. And that's what the Kenyan jurisdiction on advertising is about. Okay. Let's look at liability of advocates. I think we did liability of advocates. We did that one. The rest is just for you to peruse the notes. Let's look at advocates, disciplinary process, and then CPD. And then we will look at this thing, it's called contempt of court, okay? Advocates disciplinary, let me present. I believe I'm not presenting now. Let me present, at least now I've remembered that one. Advocates disciplinary process. Sasa, I have been talking about this, and the reason I was talking about this is because I really wanted to hint on it so that when we get here, we don't even suffer, okay? At some point, if you abuse your duties as an advocate, if you're liable for professional misconduct, you have to find yourself in such circumstances, okay? You will find yourself a complaint commission. You've been reported to the complaint commission, which is the ACC, Advocate Complaint Commission, or in some instances, you're even supposed to face the disciplinary tribunal. And this usually occurs because of professional offenses, okay? So why do you need a disciplinary process? Of course, we want to ensure that you abide by a strict code of professional conduct. You have to deal with your client, public, colleagues, everyone in a manner that is allowed under the law, okay? So what is the legal framework? The legal framework is Section 2 defining for you a client, Section 2 defining an advocate. Your name has been duly entered in the role of advocate, or there are some who have a rank like the role of senior counsel, and you've seen Ahmed Dunasir's brushings with the law because of his desire to tweet and just undermine the judiciary, okay? And then that same Section 2 will describe the client for you, okay? And then that Section 2 will describe the disciplinary tribunal. And then it will describe the unqualified person for you, okay? So, what does the Law Society of Kenya do? What does the Law Society of Kenya do? It ensures that you, as a lawyer, it checks you as an advocate. You are treating the clients with care and due diligence, okay? Because these are like consumers. These are like your consumers, and they safeguard the public interests to make sure that everything is fair, effective, transparent, okay? And if we look at now the institutional, we've been looking at the legal framework all that time. So there's the Advocates Act, and then there's the LSA Act of Kenya. Now the institutional framework of advocates disciplinary process. Number one, we said Advocate Complaint Commission, ACC. This one I've mentioned. And this Advocates Complaint Commission, it is established under Section 53 of the Advocates Act, okay? Okay, and it has commissioners, it has a secretary, it has state councils, it has registries, it has support staff, it has a CID officer, okay? It's a big commission. It is a big commission. It has houses up, kuna places you can be sent, go to that wing for resolution. Here we are doing prosecution. Here we are doing this. So it is a huge place. The office of the advocate, complaint commission. And what are their powers? Number one, they will receive and prosecute complaints of professional misconduct. We have been saying this, okay? Any professional misconduct will first go to Advocates Complaint Commission, okay? Because that is where they're reported. And then what will they do? they will say, let's try and promote reconciliation. What is reconciliation? It's part of ADR. They'll say, let's just make this amicable for you guys. Well, client, you feel like your advocate did this. Okay, why don't we sit down and agree on this term? Okay. But there are now some issues which might be beyond a reconciliation. These are not disputes to be settled anyhowly. So what happens to this dispute? These disputes will be referred to the advocates disciplinary committee or tribunal, okay? So we were talking about what? We were talking about ACC, Advocates Complaint Commission. And they have done their best after receiving a report, and they have decided to promote reconciliation or settle this dispute amicably. And sometimes they even say this dispute does not hold water, okay? Hakuna course of action hapa. Hakuna kitu hapa. Because sometimes some things can be malicious, okay? Janet Kangethe, your hand is up. If you wish to ask a question, please ask. Do you need me to, let me assume you need me
No,
to
no, the
increase.
font is the font. Yeah, it's the font.
Okay, I got you. I'm so sorry for not realizing. So, hii story yetu pia imekuwa tamu. So now, they will say we cannot do this. This is malicious. They just throw it out, okay? So that is the ACC. But then they decide, this one is, these are forces beyond our ken. So what do? Let's refer this case to the Advocates Disciplinary Tribunal. Let's call it ADT, okay? Then when now they refer it there, it is handled to, to its fullness. If you're not satisfied, you can appeal, okay? Or you can ask for them to review it, okay? Sawa. But before we get there, let's look at the jobs of other functions of the Advocates Complaint Commission. They also conduct public education and awareness. You see this legal aid week easy. Sometimes you see Katiba Institute wako huko wamejitolea, FIDA wako huko, organizations to do with children. If you look very well, you will see a tent, kutakuwa na Attorney General, kutakuwa na LSK, kutakuwa na Advocate Complaint Commission. And they'll be there and they'll be educating the public. They'll be saying, these are the duties of an advocate and these are your rights, you as a client. So if something happens, here is where you come, okay? Here is where you come. They also give advice on the status of advocates' professional standing when seeking employment. Wewe advocate umesumbuana huko X, you're being told every day, stop undermining the court because the matter is they usually say sub judice. So wewe stop undermining, and you're there undermining the court. Unaendelea tu. And then now one day, you need a serious employment in public service. And that is the day you will realize that these people are watching. Okay, Big Brother is always watching, okay? So what does the disciplinary committee do? The Complaint Commission is established under Section 53 of the Advocates Act. The disciplinary tribunal or committee is established under Section 57 of the Advocates Act. So what does it do? Just know that all advocates, okay? All advocates are subject to the jurisdiction of the DC, except those in Section 10. And I told you that those in Section 10 could be the AG, Solicitor General, any person in the AG's office. Them, they'll be dealt with differently, okay? So they will determine complaints of professional misconduct against advocates, okay? And these complaints are usually given to them by Advocates Complaint Commission, okay? If it's not a member of the public, it's the Advocates Complaint. Ile tumetoka tu sahi, they will give them. So they will determine the complaints, and then they will also do what? They will sit as a tribunal, okay? They will sit as a tribunal as they're determining the case. It's just pretty much determining cases of professional misconduct. So how do you file a case? How do you file a case? Now, the Advocates Complaint Commission, Kamiri John Zima, how do you file a complaint against an advocate? How do you file it? You, number one, the grounds where you can go to this Advocates Complaint Commission, because that is where you go to file a complaint. The grounds are, they could be, the advocate could be withholding a client's fund, okay? We said betrayal of trust. They could be failing to attend court on behalf of a client. They could be failing to update a client on the status of their case. They could be negligent, okay? And they could also be compromising a client's case without their consent. So how do you lodge a complaint? You go to the ACC offices, okay, or the Attorney General's offices, and you get a form, or you can download the form online, okay? You download the form line from the ACC's website. You complete it and make sure you state your complaint there, and then you submit that complaint. If you are in the offices physically, you get the form, complete it, and then you submit it. So what ACC will do, they will review your complaint and see if it's valid. If it's not valid, hiyo itakuwa dismissed papo hapo, okay? If it is valid, then they will say, hey, all parties come. They will try to put you through dispute resolution, ADR. If you guys, if it looks like is ADR, then the matter will be referred to the ADT, Advocate Disciplinary Tribunal, or ADC. It could be tribunal or committee, okay? It will be referred there and they will say, hii hatuwezani nayo, nyinyi chukueni. So I guess up to there, we are very clear. Tumejiripit vizuri, we have done everything we can to explain the Advocate Complaints Commission. Just remember that when you're called as an advocate for your commission, the rules of natural justice apply. You have a right to be heard. You have a right to be heard. Hawatasema tu wewe unastakiwa na kwa sababu ya hii story tumeamua sasa tuna pronounce this, we are expelling you or suspending you, or we are doing this to you. Apana, they hear both sides, okay? Rules of natural justice, right to be heard, will apply. And of course, professional offenses are when you're acting as an advocate and you're unqualified, or you don't have an active practicing certificate. Tumesema when you're being negligent, when you fail to attend a client's case, when you mislead the clients knowingly. Those are some of the grounds that might lead to you finding yourself under this commission or under the tribunal, okay? So let's look at the next one is, let's look at CPD. CPD, I said it and I'm going to say it very fast again. Let me present CPD. What is CPD? What is CPD? And this is continuous development, continuous professional development. Let me tell you, the moment you're admitted to the bar as an advocate, usiseme hii story imeisha. Usiseme sasa mimi hakuna siku ingine nitawahi soma. Every year, you're supposed to find 5 points. You're supposed to find 5 points, score 5 points in order for you to be given, to renew your practicing certificate, okay? So CPD is continuing professional development, okay? You're supposed to score points, and there are several ways of scoring these points. What is one way of scoring these points? I had said you attend a seminar, okay? You attend a seminar, that is one of the way. What is the second way? You can do a research paper, you can represent people pro bono, you can attend a discussion group, and there are several ways where you can score this CPD, okay? So I just want you to know that there will be a continuous development, professional development exercise that you will be doing every year in order to renew your practicing certificate. Sawa sawa? Sawa sawa. At this point, I am only mentioning everything that is important so that we try and do at least one a professional ethics question, okay? So what is the purpose of the CPD? The CPD is that the law profession, LSK, wants to ensure that professionalism is maintained. These questions, these points that you score, you usually score them, it's like reminders. It's like reminders of what you did in school, okay? So they're keeping you relevant, they're keeping you informed. And if there's any change in any law, then it is at that point that you will discover, have we amended any law? Have we come up with any new acts, okay? So CPD is very important. It keeps you informed, it keeps you relevant, and it also keeps you professional in the sense that you are still able to deliver. You don't rust off, you don't wear off, okay? And then another thing is that it brings unity between the advocates, judges, judicial officers, and prosecutors, because now we are reading from the same page. Do you know this and this happened? So now we are reading from the same page, and this is a good thing for us, okay? Sawa. Let's look at Lien. Let's look at Lien. Lien. And then after Lien, I think share. Right here should be Lien. What is a lien? This is a right to retain property belonging. It is a right by you as an advocate, okay? You hold the property belonging to a client, okay? Or their money. Sometimes you had the client's money. So this is a right for you to hold it until they have made your payment, okay? It is a remedy. It's a remedy available to advocates. The law allows you. Haujalipwa, wewe fanya hivi, shikilia hii property, okay? This is it is available in statutes, and it is also available in common law, okay? So under common law, it's usually you can be given property recovered or preserved by you, okay? Wewe ndo ulisaidia kurecover hii property, ama wewe ndo preserve. You went over there for mareva, okay? You went over there for it is called arrest before judgment, eh? And then there's also attachment before judgment. Wewe ndo umefuatilia mpaka now this property is in good hands, eh? Na mmeshinda. And then now this client is unable to pay you. So what do? You exercise the right to lien. You exercise the right to lien. What do? You hold the property until ile siku utalipwa. So we have the common law lien, okay? We have a conventional lien. That one you agree. We shikilia hii kwa sababu there's no other, the law cannot create an agreement for you in these circumstances. We shikilia hii, then nikipata do nitakuja kukulipa, alafu tumalizane, okay? We also have deferred lien. This is a lien effective at a future date. By hiyo siku ukimaliza hiyo story and I have not settled, then we can do this, okay? We also have retaining lien. So I say all these documents, all these papers I'm supposed to give you, but you have not paid. So let me retain them as your client so that you can pay. I've seen instances where they have like a certificate of title. Ameshikilia tu. Ako tu na certificate of title. Ameshikilia tu until ile siku atalipwa. And then of course we have equitable lien, and it's different from the one in common law. So what you did, what you do, not what you did, okay? It is an equitable lien, so it will be enforceable in equity, okay? You don't have to be in possession of the property, okay? You don't have to be in possession of the property. So just know that a lien is you holding a property until what is owed to you as an advocate is paid. So when does an advocate qualify for a lien? When a retainer is terminated, either by the client or by the lawyer for a just cause, okay? Halipwi sasa, okay? Halipwi. And it has come to a place where all the money that you spent as an advocate has not been paid, okay? You're trying to tell them, your client has terminated this retainer. You're not giving me any money, and I spent this and this in good faith because of necessity. There are issues of necessity, and up to now you have not paid, and I still have your certificate of title. So I'm going to hold on to this until you pay me what you owe me, okay? And you must just know that the nature of lien does not give you possession of that property. It does not give you possession of property. What it does, it allows you to exercise a right so that this client is compelled to pay you. And if not, then the court may intervene and give you remedies in equity, okay? Remedies in equity. That is all we need to know now for Lien. I want us to go to the past paper for 2024 and contempt of court, which I believe are both in a different location, contempt of court, and the past paper for 2024. So let me just open that. Let me just open that for a minute. Alafu, I'll present as soon as I get it. Sent. Exams. Let me open the exams and then we deal with it from there. Exams 2024. Does anyone, if you have the, I'm opening, don't worry. If you have the paper for 2024, why is my computer telling me I'm offline? If you have the paper for 2024 professional ethics paper, you can keep it on standby. Keep it on standby. My computer is telling me I'm offline, and I don't know why that is happening. Let me, just to be safe, let me read the question. Let me tell you what the question is about, and then we briefly talk about it. I had it somewhere in my book. Okay, I had it somewhere in my book. Because of time, I want to release you in the next maybe 5 to 10 minutes, so that tomorrow, kesho asubuhi, you wake up early for the exam. The question, if you look at it for 2024, it's on the duties of an advocate. It is outlining a situation where the advocate is really acting not in the best interest of the client. They're not being honest. They're trying to push dates for cases, okay? And they're also sort of working with the opposing sides. So you're being asked to identify the 5 breaches of advocates' duties or acts of professional misconduct that were performed by this advocate, okay? And so you look at the duty to client. What the duty to the client? They owe the duty of good faith, okay? They owe the duty to act in the best interest of the client, okay? They owe the duty to inform, to keep the clients properly informed, okay? To allow the clients to consent, not make decisions for them, okay? And then they also have the duty to give the clients the overriding objectives, which they don't do by prolonging cases, and they keep on trying to postpone cases, okay? And then they also have, they're trying to enter into invalid agreements, Section 46 of the Advocates Act, which is not allowed. They're just bad arrangements. They want to buy something cheaply from the client, okay? And then B was about instances where pro bono applies, and how can you, in what situations can you do pro bono? You can do it, of course, on a personal level, or it can be court ordered. Of course, in criminal cases, it is court ordered. And then you can also do for family and friends, you represent them for free, okay? You can do pro bono. And who are the subjects of pro bono? We talked about aliens, we talked about refugees under the Refugee Act, we talked about persons under criminal and civil jurisdictions, we talked about children, okay? Think of those subjects, as long as they are not companies, corporate bodies going through insolvency, bankruptcy. I'm talking very fast, so I stammer and kila kitu, okay? Then number 2 was basically duties of lawyers, so that you avoid public rage, because lawyers were being killed left, right, and center kwa sababu wameiba watu sana. And one of the duties was just the duty of honesty, candor, good faith. We talked about those. Your duty to the public, just to make sure that you do not do things that enrage the public, like you're touching your client's funds. Betrayal, Section 80 of the Advocates Act, okay? advocate practice rules, if you look at them. Anasema hawa malawyer wametuiba sana issues of seeking adjournments in courts so that cases can go round and round so that they can get a lot of money. Okay, so those are duties to the public. Just think of how the public can be mad ukiwazungusha neno wanasema hawa lawyers ni wezi. Okay, how wanazungushwa aje? Sometimes lawyers steal from their clients. Okay, and what is the role of LSK in protecting advocates? It will subject advocates to, number one, the commissions and the disciplinary tribunals. It will represent advocates. It's one of their own, okay? And it also plays, it's a part, they are a part and parcel of the bodies that enact laws to govern the advocates, and that includes their protection. Okay. Then the other one was, how do you avoid conflict of interest? Okay. And I wrote the Kingul and Mills case there, and the Rakusen Ellis and the Okotobado versus Wajakoya. This is the 2024 paper. Naongelea sasa question 3. So if you're looking at it, you can see what I'm talking about. And then question 4 was about advertising. Hey, someone there that advertised on Facebook made videos for YouTube about their law firm. Okay, so what is the restriction for this person? If you look at the advocate marketing and advertising rules, you will realize that you're only allowed to advertise on print, on your door, and in your website. Okay, so you're not allowed to advertise on social media, on billboards, on radio, on TV. Okay, why? Because of their advocate practice and advertising and marketing rules. And the law is George Okenyo Omwanza. Okay, and what is the rationale? The courts are saying this is the legal profession is a noble profession. Okay, it is a unique profession, and they're not going to water it down by putting information about lawyers undercutting and competing everywhere, because we have the cab rank rule to go by. Okay, and then we have our restrictions in the profession, and we're supposed to keep it as is. Okay, and then number 5 was about professional undertaking. And of course, professional undertaking, if someone in your employment gives a professional undertaking, you will be liable. And this unequivocal declaration, when you give it and someone places reliance on it, then when push comes to shove, you will be held liable. Okay, and 5B was about someone practicing without a practice certificate. Okay, and so I put there the case of Wilson Dolo Aya. Okay, National Bank of Kenya versus Wilson Dolo Aya, where the advocate Violet did not have an active practicing certificate, and they went ahead to endorse documents. So there was that. And I think that's basically the question paper for 2024. What I will do right now, I will just remind Senior, if he hasn't, I want to remind him to send you all the presentations that we've talked about today. And from this, when this class ends, I want you to take 30 minutes. Take a lot of fluids, stand up so that you have a health break, and then go through those slides. I've tried to make it very few. Most of the pages you've seen, they have seen 6 to 8 pages. But the ones that are long, they're not long because you need to read everything. They are long because they are my personal notes that I hope to introduce to the next class by next year, January or February. Okay? They're just personal notes. So they're not supposed to be that long so that you're supposed to cram everything. Only go through what we've gone through so far. Okay? Is there any question? I'm trying to find contempt of court. Is there any question as I find contempt of court? If there's any question, you can lift. Kimani Wainaina, you have a question. Please go ahead.
I hope you can hear me.
Yes, I can hear you.
Okay, yeah. In my reading, I saw when it comes to insurance, I was confused because it was giving 2 different amounts. One was for 1 million, the other one was for 3 million. So I just wanted to know which amount the one that you need to get practicing certificate for the year, or are they 2 different amounts for two different things. I was a bit confused on that.
Okay, thank you for the question. The least amount that you can take up to 1 million, okay?
Yeah.
The least amount that you can take is up to 1 million.
Okay.
Okay.
And
there any
that's
other-
for the practicing certificate.
That's for when you have a farm. You have a law firm, all right?
Mm-hmm.
When you have a law firm, your own law firm, you have to take an indemnity cover. For your practicing certificate, it's a very small annual fee that is usually paid it's paid annually. I want you to separate the two, okay?
Okay.
Okay.
Thank you.
Yeah, it's different. Sawa.
Thank
There's
you.
be what? Yeah, thank you. Be what, Ivy? Be what, Ivy?
Can you hear me?
Yes, I can hear you.
Okay. From my reading, I realized that SOPEC 4 does not permit contingency fee, but from your presentation, you said that it can be allowed in certain instances. If you could kindly clarify on that.
I'm thinking of a situation. Yeah, it's a tricky, you realize it's a tricky situation. Kwambia mtu ukishinda ndio utanilipa, si ndio? I'm trying to think of a situation. Can we we know you can be asking the question as I do a quick research on when to ask for. It's Owino Alpha. Owino Alpha, your hand is up.
Yes. I wanted to inquire. There is this question that I was once asked somewhere, and I wanted to collect your thoughts on that because I answered it wrongly, but they didn't tell me the answer. So, are senior councils subject to SEC and ADT?
No, they are not. They are not. Did we separate them? Yes, we did. We did separate them in the alongside the other people that we just. No, you don't have your nini yet. It's okay. You will get them in a few. I just want us to go to those tribunals, advocates disciplinary process. And Ivy, I've not forgotten about you, okay? Usiseme.
Madam, I had a follow-up.
Yes, please.
I wanted to ask now which disciplinary mechanisms are available to the senior councils?
The senior councils, they can be striped off. They can be striped off there, Nini. What is it called? That it's an honorary title, right?
Yes.
Yeah, it's just taken away from you. That is one of them. Kwanza kuna mtu amesumbua hata kuna cases za contempt of court. This our uncle, Grand Mula. You know Grand Mula?
Yes, I do. Actually, it's him who led to the question. It's his conduct that led to the question.
Yes, him has been striped off. So in this situation, it can be striped off. And then if you owe the client any say he has represented the client and they owe something, then things like in civil litigation could be specific performance. You just give normal remedies you would give, but then you don't suspend them from being from being senior counsels. Usually it's something that should be striped off, but has it really happened in practice? It's not something that has happened in practice, okay? I'm looking for Ivy. I'm looking for your Nini for your answer as well. Oh, we know. Have I answered you?
Yes, you've answered. And then there are certain questions that have been sent in the chat, so you could just scroll through as so that you give answers to them.
Okay, let me look at the chat so that I see and give the answer. And Ivy, I'm looking for that situation. Sitaki kusema kitu ya uongo. Hiyo tutapata hata kama tutaipata the last one. So just hang in there. Can we ask for PowerPoint presentation to be shared? Yes. Jacktone, can mute her. That was someone ule alikuwa anaongea. Please explain the extent of confidentiality when holding brief. Okay. This is in the situation where you need to, are you asking about holding brief? Are you asking about holding brief or watching brief? Which one? Because watching brief is like in criminal cases, they will send you to, a complainant can send you to to attend on their behalf. Okay, usually there's a prosecutor, but they just send you and tell you, able just follow up on the case because I'm not directly involved. Okay, holding brief is when a lawyer sends you. Okay, so in holding brief, whatever you have been communicated to by this other advocate, whatever has been communicated to you should remain confidential. Number two, consent. After that should be number one. Put it the other way around. Let there be consent. Let there be consent of the client before you undertake anything. Okay? Malimu, please expound on the process of application under the process of applications, section 43 of the Legal Aid Act. Now this, I said it's not an absolute right. This is a right that is available to aliens and refugees under the Refugee Act and children, and for criminal cases, they don't just give you and tell you, here is a lawyer. You make an advocate, you make an application, okay? You make an application to the legal aid services, and then they give you an advocate. However, I said the practice is different. In court, usually it's an advocate. Ebu ita fulani, they call an advocate. Ebu mpeleke kwa admin ajaze details zake, and then the person will come down and say, now, I'm the person's advocate on record. I wish to go on record, and I would like to be briefed. So I'd like to ask an adjournment so that I can be briefed by this client, and so that I may be able to prepare the necessary defense. Okay. What is the difference between proper brief and pro bono? It's like the difference between tomato and tomato. Same thing. It's the same thing. Okay. Although for the most part, pro bono will be used in the Kenyan context. It will be used in criminal cases. Okay. Proper brief now will be used, say, for the people we were calling refugees and aliens and the others. But pro bono inakuanga sana sana criminal cases, capital cases, and now this person needs a lawyer. Okay, does the concept of the Chinese wall apply in professional undertakings by a partner? What is the concept of the Chinese wall? You people will show me things. Concept of the Chinese wall. And Nani, Ivy, I want you to know I'm still researching. If this means taking your email, I will take it. Okay? A virtual barrier intended to block the exchange of information between departments, if it might. I do not understand your question even after looking at the definition of a Chinese wall. Okay, make it easy. Make it easy. Tell me what in your view is the Chinese wall. Okay. Some people are saying, can't hear mwalimu, chop chop rice, chop chop. Okay. I had stopped projecting. When an advocate explains certain factors of law, e.g., summary, dismissal in employment, through their social media accounts such as LinkedIn. Does this amount to advertisement? No. Advertisement is, hey, come for our services. We will win this case in the morning. We are based in Kilimani, this building, room 10. And these are our achievements, okay? So an advocate talking about factors of law, like summary, dismissal, like those who teach, that is a different thing. Those are different achievements. They are just adjacent, law adjacent, but they are not advertising. So do not start saying, for more of this, come to our offices for excellent legal services at Kilimani. I hope you catch the drift. Is the senior counsel bar subject to ADT? Or you had asked that and I told you no. Nope. Grand Mula, me, I just see him being taken to the other courts, okay? He's never been in front of the commission, and he's never been. I think in one instance that he was in front of the tribunal, it was said that the tribunal did not have jurisdiction. There was that argument, okay? What can be termed as civic education? I hope you're talking about the Legal Week or the Legal Aid Act. What they give is usually civic education. It's legal and it's civic. When an advocate explains certain factors of law, 24 paper, I will share everything. No, you have your question papers, but I will share everything. Okay, which one handles unprofessional conduct and which one handles professional misconduct between ADT? So professional misconduct will be handled by ADT. Okay? Professional misconduct will be handled by ADT. Unprofessional conduct, ACC. And then there's someone who's written, Miracle Mudei, Section 19 of the Advocates Act, disciplinary mechanisms against the senior counsel. And thank you so much for bringing that to our attention. That's the farthest I can see. I don't know why they're telling me I'm not a member of the chat. I wasn't given permission, but I'm also seeing that time is running out. Guys, let's make a deal. Let's make a deal. Let's ask 2 more questions and then I call senior to conclude the meeting because of your time. You guys need to go through these documents on your own and rest. Please. We have done the best we could. 2 more questions. So far, I don't see any hand raised. Ivy. There's Opimbilin. Opimbilin ask.
Can you hear me?
Yeah, I can hear you.
Okay. So, question, does holding brief amount to an advocate-client relationship, or to what extent would it amount to?
Up to the obligation this advocate holding brief is supposed to perform. If you're supposed to continue with this case till the end, all that time and even after, and up to from the time you were briefed, okay, from the time you were instructed, you are told what the case is about, and the time you're representing the client, and even after the relationship ends, there will be an advocate-client relationship. What you're doing, holding brief, is me stepping in your shoes. I will do what you would have done. So what I'm supposed to keep confidential, I will keep confidential. All your monies that I'm supposed to keep safe, I will keep safe. All the notices, the letters I'm supposed to send you, the legal opinions I'm supposed to send you, I will send you. Anytime you try to further an illegality, I will break our relationship because I owe a duty to the court. Think of it as you're just stepping in another advocate's shoes. You're trying to do exactly what that advocate does, okay? I hope you're answered.
Okay.
Yeah, is there someone else whose hand is up? Because Kihara Gabriela.
Hello, can you hear me?
Yes, I can hear you.
Oh, my question is, can a professional undertaking be given to a non-advocate?
Can a professional undertaking be given to a non-advocate? Do you want to give me a situation, because I am seeing this and then I'm not seeing it? Can you give me an example? Who are you thinking of in this situation?
There was a silly question where an advocate for the purchaser gave a professional undertaking to the vendor. And now the question was whether it can be enforced.
Whether it can be. So who was the advocate again? The advocate, sorry, yeah, what was the role of the advocate? The advocate was the advocate for the purchaser or the vendor?
For the purchaser.
For the purchaser. Yes, because the one with the money is the one who gives the professional undertaking. Cindy, give us this, and then we promise to use this for this particular a function or reason, and then we will give back this, or we will give this in return. You understand?
Yes.
Yeah, so it is enforceable because it's the purchaser who had the money. So let's have Kamiri John I also want to text Senior to tell him to be on standby. Ivy, what I'll do, I'll answer your question, send it to Senior on email, and then Senior will send it to you. I need to do research. I'm afraid I do not have a straight example for your situation right now, and that was a really tricky question. Okay, Kamiri John, go ahead and ask.
No, mine, I just wanted to slightly feel like it is not possible for an advocate to offer a PU to an advocate because of the situations upon which you are supposed to. You see, one of the ways of the undertaking, and I think it is the major underpinning, is that if I give a PU and I do not perform, I'm held as professional. It is held as a professional misconduct, and therefore, I don't see why I don't see the non-advocate to use that route.
What is the
how will be now an
what is the equip agency case that I talked to you about? The equip agency case versus Credit Bank. It was a law firm. It was a bank. It was a bank actually. Yeah, it was a bank giving a professional undertaking. A bank, of course, through their advocates, giving a professional undertaking to this company, Equip Agencies. Okay. So what I can tell you is that for the most part, when this relationship exists, each side usually has a counsel and an advocate, okay? But in some situation, it is not uncommon.
Yes, that's exactly what I am.
Yeah, it is not uncommon for you to find that one side, especially the recipient, does not have an advocate, okay? Okay, Kamiri John? Kamiri? Okay, you've disappeared.
I'll take it for yes.
Yes.
No, I'll take it for that for now.
Okay. So Yator, please ask the question. I'm texting Senior to just wind up the meeting. Nataka mpumzike.
Immaculate. I
yes.
think there's an answer you've given. I didn't get it quite clearly, whereby an advocate is holding brief, and whether it can amount to an advocate-client relationship. For the advocate who's holding brief, you're an advocate, you're holding brief for a colleague.
Yes.
So can it create an advocate-client relationship with the client of that colleague? I think I didn't get the answer quite clearly.
It does, depending on the circumstances. They can be jointly and severally. You've had that term, right?
Yes,
they can be, yeah, if there is a if we are looking for whom to hold liable, it could be an individual advocate, says the one that was holding brief.
Yes.
It could be both of them, which is jointly. And if it's many, it can be severally. So this varies on a case by case basis. If the breach has happened through the advocate who was holding brief, by virtue of being an advocate of the High Court of Kenya, you catch the drift?
Yes.
Do you think they're supposed to not owe this client any duty because they're holding brief?
On that line, I think they would owe a duty.
They would owe a duty. They cannot come on board and say, whatever happens, it's not my client. Just by being an advocate of Kenya, of the High Court of Kenya, you automatically owe that client a duty. Sawa.
Okay, noted.
You owe them the duty. So I think I've answered the questions enough. I've sent a text to Senior. Ivy, remember to check your email at some point. I don't know, you send your, no, I'll send the the results to senior, alafu atatuma kwa those groups, the WhatsApp groups, and then you'll pick it from there. I remember your question very well. Instances where contingency fee can be considered, because it's a nini that is used very rarely. Okay, so I cannot seem to see senior. Let me just flash him. Oh, senior, are you there? I would like to call it a night if you can hear me.
Yeah, I can hear you.
Yeah.